Can you find out for what? Oh, we do what? You can ask me if minutes in the email or anything about culture.
Most people want.
Is in custody.
Yes, sir.
That's gonna be a waiver. Waterford is a waiver.
Yes.
He can be brought up. State of Michigan versus David Brown, 26-02261, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Good morning, Your Honor. Eric Shepard here on behalf of David Brown. We're both present in person in the courtroom, and Mr. Brown is standing to my right.
This matter was scheduled today for preliminary examination on carrying concealed weapon, possession by a prohibited person, and felonious assault and felony firearm. My understanding is that there is going to be an unconditional waiver today. Is that accurate?
That's correct, Your Honor. We people unconditionally waived, and I believe the defendant is going to also waive.
Yes, Your Honor. It is going to be an unconditional waiver. My clients received an offer to plead to the felonious assault and the carry concealed weapon and dismiss the remainder and balance of the complaint. We're going to waive up on that offer and continue discussions and negotiations in circuit court. I've also put in some discovery requests for the body worn camera footage from 3 different officers, Officer Jackson, Grunberg, and Jenks from the Lansing Police Department. My understanding is that that has been requested, and that will be ongoing discovery in circuit court.
Okay, Mr. Brown, you understand your right to have a preliminary examination here on these felonies that you're being charged with? You understand the purpose of the preliminary examination? You have the right to have the prosecutor establish on this record that they have sufficient probable cause that a felony was committed and sufficient probable cause to charge the person who committed those felonies. You understand that? You wish to unconditionally waive your examination today? I can't hear you.
Yes.
Anyone threatening you to get you to do that? Extended to you in exchange for you waiving. The bind over date is going to be May 13th. That's the day the circuit court's going to receive the file from the district court, not a court appearance date for you, okay? Your next court date will be a pretrial. Your attorney will be made aware of that. Can you confirm your phone number for me, please?
517-899-1456.
Your address.
2005 Eagle Ave.
Okay. It's your responsibility to update any changes with pretrial services, should that be needed. Bond was set at 2,000 personal recognizance. That will continue. Any additional matters for the record?
So from the people, Your Honor.
No, Your Honor. Thank you.
Thank you. State of Michigan versus Oscar Gonzalez, 26-00984. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people. I think Mr. Gonzalez is on Zoom.
He is via Zoom, but you're muted.
Good morning, Your Honor. This is Rochelle at Fred's office. He just jumped into another courtroom in Jackson. He will be right on in a minute.
Okay,
That's what
we'll
he
call
told me.
this when he's available.
Thank you.
Okay, let's see. State of Michigan versus Christopher Dang, 26-00977. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Jacob Riley on behalf of Mr. Dang, who's present to my right.
Dang had a police officer assault preliminary examination today, and there was an assault and battery that accompanied. My understanding is there will be a waiver to the circuit court. Is that correct?
I guess you're.
And the previous offer that I had noted was plead guilty to count 1, dismiss count 2. That's still the offer.
Yes.
Mr. Dang, you understand the purpose of the preliminary examination?
Yes, ma'am.
You understand your right to have a preliminary examination here in the district court and required that the prosecutor establish sufficient evidence that there's probable cause that a felony was committed and then probable cause sufficient to charge you as the person who committed the felony.
Yes, ma'am.
You wish to unconditionally waive your exam?
Yes, ma'am.
Any threats to get you to do that?
No, ma'am.
Any promises to get you to waive?
No, ma'am.
Bind over date is May 13th. That's the date the circuit court receives this file, not your next court date, okay?
Yes, ma'am.
Your next court date will be a pretrial. Your attorney will be made aware of that. You stay in contact with your attorney. Confirm your address for me.
5821 Richwood Street.
That changed since you were arraigned?
No.
You gave the address of 3510 South Deerfield on April 10th to the magistrate.
Those are the two addresses I bounced in between.
We don't want your bounce in between address. We want the address that you will live at and receive your mail.
I don't receive mail at the location I'm at currently, but the current address I'm at is 5821 Richwood Street.
Apartment 9,
Yes, ma'am.
what's your phone number?
517-215-0183.
Bond is set at 1,000 personal recognizance that will continue, as well as a no contact order with a Brandy Shaw Reed. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set. Back on the record in the matter of the state of Michigan versus Oscar Gonzalez III. Counsel appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appear on behalf of the people.
Your Honor, Fred Blackman on behalf of Mr. Gonzalez on Zoom. He's in my office on Zoom also, Your Honor. For today, I'm in Jackson Circuit Court. I apologize about that.
No problem. Today was the date scheduled for a preliminary examination. It's delivery, manufacturing of drugs and a weapons charge. And my understanding is that there's an unconditional waiver entered in today. Is that accurate?
Yes,
Yes, it
that's
is,
the
Your Honor.
people.
Was there an
Yes, Your
offer,
Honor.
counsel?
Yeah, I believe the offer was the delivery, manufacturing, that we would dismiss the felony firearm.
That's your understanding of the offer, Mr. Blackman?
I do, Your Honor. We acknowledge that there is an offer at this point, but we will continue negotiations up in Circuit Court.
Oscar Steven Gonzalez III, correct?
Yes, Your Honor.
You understand your right to have a preliminary examination on the felonies that you're being charged with?
Yes, Your Honor.
You wish to unconditionally waive those exams on those files or those charges?
You said sorry. Say that again, Your Honor.
Do you wish to unconditionally waive your right to have an exam?
Yes, Your Honor.
Are you sure?
Yes.
Okay. Anyone threatening you to get you to waive your preliminary examination?
No, Your Honor.
Any promises to get you to waive your examination?
No, Your Honor.
Your bind over date is gonna be May 13th. That's the date the circuit court's receiving this file,
Okay, Your Honor.
not your next court date, okay?
Yes, Your Honor.
Your next court date will be a pretrial. Mr. Blackman's office will be made aware of that. You stay in contact with him. Do you have any questions at this time?
No, Your Honor.
Okay, bond was set at 15,000 personal recognizance. That will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor. Thank you very much.
You're all set?
Thank you.
You're welcome. State of Michigan versus Xavier Botiford, 26-00985 FY appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appear on behalf of the people.
Attorney Luke Goodrich from the Public Defender's Office filling in for Jared Austin today, representing Mr. Bodford, who is standing to my right.
Mr. Botiford has a possession of methamphetamine and a resistant obstruct officer, habitual fourth offender. Notice has been filed. We were scheduled for examination today. Are we having an exam?
Your Honor, Mr. Boudreaux would like to waive his preliminary exam at this time and pursue a plea offer that was made by the prosecutor's office.
I see that the offer previously was to participate in drug court.
That is correct. It appears they're going to pursue that in circuit court.
Mr. Rutherford, do you understand your right to have a preliminary examination, correct?
Yes, I do.
And you understand the purpose is to require that the prosecutor establish sufficient probable cause that a felony was committed and a probable cause sufficient to charge you as the person who committed the felony?
Yes.
Do you wish to waive unconditionally? Your bind over date is May 13th. That's the date the circuit court's receiving this file, not your next court date, okay?
Okay.
Next court date will be a pre-trial and circuit court. Your attorney will be made aware of that. They'll be in contact with you. Do you have any questions at this time?
No, I don't.
Bond, 7,000 cash surety. Will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
You're all set. Bring Cardenas up. Look at the response.
Jax Flores or Priya Patterson.
What exactly? Got it. State of Michigan versus Jessica Flores, 26-00364. Council appearance, is Jessica Flores here?
Yes.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
George, in his APD, on behalf of my client, is staying to my right, Your Honor.
Your client was scheduled for sentencing today. It looks like it was for domestic violence. There is a pre-sentence report prepared on the 28th. Did you have an opportunity to go over that with the client?
Yes, Your Honor.
Any need to make corrections, updates, or deletions?
No, Your Honor. Actually, my client believes that the jail, I reasonably believe the jail credit might be off. I believe it's less than 4 days. I'll leave that to the court. I'm
You
not
believe
certain.
it's what?
Less than 4 days. My client believes she only did about a day in custody on this, but I'll leave that to the court. That's just something that,
I would agree. I mean, she looks like Should be some money on the 14th. I got a PR bond.
We would appreciate the 4 days, but we know that's time and effort. Other than that, no, Your Honor, no other addition, deletion, corrections.
Thank you. You can make allocation.
Your Honor, my client is indigent, currently unemployed and receiving government assistance. We would ask court to waive fines and costs on the alternative, allow any assessment to be paid over the term of probation. She's actively struggling to secure employment while also working on trying to get daycare for her child. We respectfully ask the court to grant a deferral under 7694A and to follow the recommendations set forth in the PSI. Since this incident, she has been fully compliant with CPS, is engaged in classes. Both her and her son participate in counseling and therapy. By all accounts, her home improvement has been more stable and structured. She's expressed sincere remorse with me and with the probation officer, with being visibly emotional when discussing what occurred. She has taken full accountability for her actions. Your Honor, this was an isolated incident, and she assures me that this will never happen again. And she's assuring you and the court that this is a one-time occurrence that will never happen again. For those reasons, Your Honor, we would ask court to follow the PSI recommendations, and my client has something to say as well.
She wants to make a statement.
Yes, Your Honor.
My statement is just that the house is more structured in better ways. It's more loving. There's more stables now because of everything that's been processed with my son. He's getting the help that he needs more with IEPs, therapy. He's just got diagnosed with ADHD as well. So all those processes have been informed with, like, it's been ordered in the house. So everything is more loving instruction in the house, more understanding.
I can appreciate you sharing what your son is getting. What are you getting?
I'm getting counseling, and then I'm doing parenting classes as well.
Yeah, because the issue wasn't the fact that your son needed some help, it's say you need some help. And I disagree that this is an isolated incident. The son reported that his mother hits him every day with a phone charging cord. That was what was reported. So that wouldn't be isolated. Isolated meaning it happened once. Why are you not working?
Again, I have a 3-year-old. She just started preschool. It's just been hard for me to get the daycare that I need for her having fun.
Okay.
But I am working on that as well. Now that she started the preschool and everything, I just need to get more functional with the job.
Functional, what does that mean?
Functional with having baby in daycare, and then for me to.
The baby is in daycare now.
No, she's in preschool.
She's in preschool?
She goes from 9 to 3. I'm sorry, 9 to 12. So it's only 3 hours.
I reviewed the pre-sentence report and the recommendation, which is for a term of probation with sentencing under 769.4A. I will adopt that recommendation. She'll do 6 months probation. While on probation, she has the following conditions. She's not to engage in any assaultive or threatening behaviors. She's to have peaceful contact with the victim. She's the minor child. Okay. There's more than one adult in the home?
Yes.
Who's the other adult?
Stepdad.
And neither one of you are employed?
He just got unemployed.
Okay, so it's not an issue of childcare then?
Well, that's why right now I'm looking for a job. Because he just got unemployed. So.
Ordering that you find employment as part of your
That's fine.
probation. Let's see. Grant 769.4A, you're not to have alcohol, marijuana, or controlled substance while on probation. You will submit to random preliminary breath testing and urinalysis testing. You have to pay the cost of that, okay?
Yeah, she has a medical marijuana card. That should be in the PSI. Would you allow medical marijuana?
She presented the valid card.
That's what I saw in the PSA. Was it
Yes.
valid?
Yes.
Yeah, it was in the PSI. Yes, Your Honor, it was in the PSI.
Okay, you see it says it's currently valid, so that's fine. Let's see, and she's going to follow all CPS orders and recommendations. You'll report via Zoom for your probation monthly, okay? The $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that also will be assessed. There's a $30 per month oversight fee for each month of probation. $180 for probation oversight fees. The total fines and costs is $305. You'll make monthly payments on that, okay? Have any questions at this time? We'll check in with Mr. Sumter before you leave here today. Any additional matters for the record?
Nothing from the people, Your Honor.
Mayor, thank you.
Thank you. Cardenas, correct? Yes. Okay, State of Michigan versus Jessica Cardenas, 25-02661. FY appearance, please.
Thank you, Your Honor. May I please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Good morning, Mayor. Please, this honorable court, Kareem Johnson, on behalf of Ms. Cardenas, P number 71988.
Okay, today was the date that was scheduled for preliminary examination and for PA 53 contempt. My understanding is that there is going to be an unconditional waiver on the felony and that she's pleading to the violation. Is that accurate?
Yes, Your Honor, that is.
Counsel, approach for this. Was there an offer at all? Counsel?
There was no offer, Your Honor. She has matters that are going to be resolved in circuit court.
You said she has other matters.
Yes.
Okay. a possible global resolution.
Yes.
Okay, ma'am, you understand your right to have a preliminary examination? And you wish to unconditionally waive that? Can you speak up, please?
Yes, ma'am.
Okay, so that means you're gonna waive your right to have the prosecutor establish that they have sufficient probable cause that a felony was committed and sufficient probable cause to charge you as the individual who committed the felony, correct?
Yes, ma'am.
Anyone threatening you to waive this?
No.
Any promises to get you to waive this?
No.
They asked to the GPS violation, it looks like from November 10th, 2025. The court received a violation notification from JSG of a tamper. You're gonna plead guilty to that?
Yes, ma'am.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Okay, you can put your hand down. You understand your right to have a contested hearing on the violation?
Yes, ma'am.
You want to waive your right to have a contested hearing?
Yes, ma'am.
Anyone threatening you to plead guilty to the violation?
No, ma'am.
Any promises if you plead guilty?
No, ma'am.
And you're pleading guilty because you believe you're guilty?
Yes, ma'am.
As to the allegation that you tampered with your GPS tether on November 10th, 2025, how do you plead?
Guilty.
Factual basis, please.
And on November 10th, 2025, approximately 9:21 a.m., did you tamper with the tether?
Yes, ma'am.
And how did you do that?
Uh,
Let's satisfy you.
Any questions?
I didn't hear the second part.
She removed it.
Oh, no, the people are satisfied.
The court is also satisfied with the factual basis. I'll accept your plea if I have to be freely, voluntarily, and intelligently made. Did we recover the tamper? I mean, the GPS tether at all? It was recovered?
Yes.
Okay. You can address the court on sentencing on the violation.
Yeah, she shouldn't have done it. There's no excuse for doing it. She was. That's narcotics at that time. Since she's been in custody, obviously, she's dried out. So we are trying to seek a resolution that will include some sort of, if we can't get drug court, sort of inpatient treatment. She's been in custody for quite some time in this matter, 73 days. We think that is sufficient for punishment, and obviously she'll have to pay for any damages to the county.
Further time served on the violation. I think she was remanded because of this. Is that what happened without bond?
Yes, sure.
Set at 5,000 cash surety.
Thank you, yeah.
Any additional matters for the record?
No, ma'am.
Nothing for the people, Your Honor.
You're all set. Okay, State of Michigan versus Brandon Lamar Hill II, 26-00408. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Good morning, Your Honor. Attorney Gibbs on behalf of Brandon Hill, who is present in the courtroom at the podium, standing to my right.
Okay, Mr. Hill has a sentencing today for a misdemeanor domestic violence. There was a report prepared on the 22nd. Counsel, you did receive that, correct?
Yes, Your Honor.
Do we need to make corrections, updates, or deletion?
We do not.
Address the court on sentencing.
Thank you, Judge. I'm going to respectfully ask the court to adopt the recommendation and grant Mr. Hill deferral under 76948 status. Judge, right from the beginning, he has been accountable, accepted responsibility, and extremely remorseful. What the judge doesn't know, I just wanted to shed a little bit of light that Mr. Hill and Ms. Patterson Lee have been in a relationship for 8 years. He said that they've been living together, the majority of that. He said they were going through a very difficult time, financial and otherwise. He was under a lot of stress, working a lot of shifts when this incident occurred. I've explained to him he needs to find a positive way to channel his frustration, because if he continues to live, life will continue to get stressful at times. So I've encouraged him to maybe seek out some counseling. Your Honor, with that being said, I think that He is exactly what the legislators had in mind when they drafted the statute. He has absolutely no criminal history whatsoever. He's gainfully employed as an assistant general manager at Blaze Pizza. He is also a very bright and motivated young man. I just want to highlight in the report that the investigator did say that he was extremely respectful during his encounter with him when he interviewed him. That has also been my interpretation of Mr. Hill, every interaction I've had with him while representing him. So again, I ask the court to adopt the recommendation and grant him 769-4A status. Judge, I do just want to place on the record that I've explained to Mr. Hill that if he violates, if the judge does grant this and he violates any terms of probation, that judge can enter the conviction and then sentence him under the charge to which he pled. With that being said, again, I'd ask Your Honor to adopt the recommendation in its entirety.
Okay, you have a victim?
I know I previously submitted something to the court, but I just wanted to reiterate that I do not feel in fear of the defendant in any way. I do not feel as though they have malicious intent. And I would like for the no contact order to be lifted as well. Like I said, I know I did submit something quite a while ago, but I just wanted to reiterate that in person that I do not feel in fear. Oh, Priya Patterson Lee, sorry.
Can you spell it, please?
Priya, last name Patterson, Patterson-Lee.
Okay, I do have, I'm reading your statement here. It says, as the victim, I strongly believe the event in question was a disagreement that escalated on both parties' end. The strangulation action was an overstatement. What does that mean?
So I feel as though, because I honestly have never been in contact or had to talk to police before. So kind of as his lawyer stated, it was a lot going on financially, and my mom had been in the hospital, so we were both just very stressed at the time. So there was an argument that ensued, but I don't feel as though my words to the police of saying strangle, I feel like that was an overstatement. I think I was just in the height of the moment.
You said strangulation?
To the police, but I didn't realize at the moment. I was kind of just words on me.
Okay, so he didn't strangle you?
No.
Well, that's not an overstatement then. It's just not the truth.
Right, yes, correct.
You know how serious, if it's not the truth, you know how serious that is?
Yes.
Okay. It says I didn't have any bruises. Not a concern of the court, whether you have bruises or not. The concern is whether or not Mr. Hill, in fact, strangled you. That was how it was originally charged, which is a felony. And I was going to address that because, you know, there are some judges that will not give 769.4A if there was, in fact, a strangulation, because it's perceived that you've already received your reward by getting a domestic violence. But I have here a victim who said he never strangled me. And that's problematic. Like we get a lot of people where there's a lot of cases, I should say, where victims don't tell the truth because they want to salvage a relationship where they feel unsafe. And then we also get a lot of cases where victims or alleged victims don't tell the truth because they're being vindictive. And that puts people in a really bad position. It's not okay to overstate things at all. And if it was an overstatement, something should have been addressed prior to now, I would imagine.
I tried to contact, but I wasn't able to get in touch with anyone. They told me I would have to wait for these hearings in order to kind of reiterate that.
The prosecutor's office is always available. If there's ever a concern, and I would hope and pray there won't be in the future any concern. So you want me to lift a no contact order so that he can return home, or you all can?
Yes.
Okay, is that what's going on? Okay. And you all work together?
No.
No, you don't. Okay, you don't work together. You just live together, okay. I will adopt the recommendation of probation. But I will make some amendments. First, it's gonna be 6 month probation versus 10. Because obviously, there were some overstatements of what happened. Also, if you're on a term of probation for domestic violence, you can't request early discharge. So I'm gonna start you off with 6 months. Hopefully there won't be any violations and you'll be off in 6 months. While on probation, you're not to engage in any assaultive or threatening behavior. You understand that? I will allow peaceful contact with the victim, Priya Patterson Lee. And obviously, if you're all in relationships have disagreements. That's not the abnormal part. It's now how you're gonna have to maneuver to address your differences, especially during this time period, because you don't want anything to be perceived as assaultive or threatening, okay? Okay, you're not to use alcohol, marijuana, or controlled substance while on probation. I'm not gonna order testing. That was not an issue in the underlying matter. You're not to be at any bars or nightclubs. I am gonna order domestic violence or domestic abuse course through a batter's intervention. I think that could just be useful to you, sir. And you'll maintain your employment and provide evidence of that to probation. Do you understand that? I'm granting 769.4A. It's a $30 per month oversight fee that you're responsible for. $75 crime victim rights fee plus $50 state minimum cost. I'll waive discretionary fines. And probation for 6 months at $30, $180 for a total fines and costs, $305, and you'll make monthly payments on that, okay?
Yes, ma'am.
If you have any questions at this time, they'll report to probation remotely via Zoom monthly. And you'll check in with Mr. Neves before you leave here today, okay? Any additional matters for the record, counsel?
Judge, I just want to state on the record, you were obviously referencing some letter you received from Ms. Patterson Lee that I never received. I just want to encourage the prosecutor. I know they were short at a time and going through time over that they share all communications. I also will admit that I subbed in on this. It could have went to the public defender and didn't make it to me, but I've never seen that letter nor were I aware of it.
Yeah, this was sent to the victim witness unit on, it's dated March 4th.
I was on the case then. I believe I subbed in prior to that. Nonetheless, I didn't receive that. That would have been helpful.
Yeah, but she wouldn't have got it until last week. She should have got it when it was filed.
Thank you, Judge.
Thank you. Oh, you're all set. No, I'm ready. He can have peaceful contact on.
Okay, keep the, okay.
They clearly still in a relationship.
Yeah.
Okay, let's see. And then are we running Hollins?
Your Honor, Hollins
That
would
was a
be-
plea. Okay, Hollins can be brought up.
Okay.
State of Michigan versus Nathaniel Hansinger, 26-00383. Yes.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Hansinger, who is filling in for Jared Austin today, and Mr. Hansinger is standing to my right.
Okay, Mr. Hunsinger had a preliminary examination scheduled for controlled substance delivery manufacturing. And my notes state this is going to be a conditional waiver, correct?
Yes, that's what people understand.
Your Honor, Mr. Hunsinger would like to waive his preliminary exam today. It is my understanding there is a plea offer currently on the table involving a plea to possession of meth that will be available in the circuit court.
Is that accurate, counsel?
Yes, Your Honor.
Okay, Mr. Hunsinger, you understand that you do have the right to have a preliminary examination on the felony?
Yes, Your Honor.
You understand you have the right to require that the prosecutor first establish that they have sufficient probable cause that the felony you're being charged with was committed, and then probable cause sufficient to charge you as the person who committed the felony, correct?
Yes, Your Honor.
And you wish to unconditionally waive your examination?
Yes.
Anyone threatening you to do that?
No.
Any promises to get you to waive?
No, Your Honor.
Okay, let's see here. The handover date's gonna be May 13th. That's the date the circuit court's receiving the file, not a court date for you, okay?
Okay.
Your next court date will be a pretrial. Your at circuit court, and your attorney will be made aware of that. Can you confirm your phone number, please?
517-343-0997. The 249 number, that one's, it's not active right now. So this phone number that I just gave you is like temporary, but I will keep you guys updated whenever I get it.
Okay. Your phone number? I'm sorry, your address, that is.
I also need to update my address. My new address is 4904 Bell Chase Boulevard, apartment number 107.
That's what you gave me last time.
Oh,
Okay. Bond will continue at 5,000 personal recognizance. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor. Thank you.
You're all set. Thank you.
thanks.
State of Michigan versus Michaela Johnson, 26-00422. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
I don't see Mr. Rowley or Michaela.
Out in the hall looking for a friend.
Okay, well, that doesn't work. Let's see. Is Courtney O'Reilly here? State of Michigan versus Courtney O'Reilly, 25-01408. Who's representing O'Reilly? Because it says Cornish. Like the city case. It's a city case, so just a public. I don't know which public. Someone beats, someone should. Still been assigned.
Party, and he's doing arraignments.
Someone tell him if this was separate today. It's separate today, so he should have known.
How's it been separate? Isn't it separate?
Forensics, March 31st. Is there a report?
No, but I don't know if she, I have questions. about this. I just looked at it. Has she ever, those are the only reports you ever received regarding her. I don't know if she's ever been interviewed at all.
No, she didn't. She,
So I don't want to keep setting it out if that was the case. I know she's one of Nathan's clients, and so he has information, but still not.
Our records show that Joe Hardy is assigned to the case, but it's
He's
not on
had-
his schedule.
this is supposedly been on our schedule since March 30th. But I don't know that she's ever even been evaluated.
No, I have not.
And that,
This is the third time it came back to court, and I have not had an evaluation for this.
why was it rescheduled?
It would have been rescheduled because she failed to appear, so we had to do another competency referral. And it looks like she's just not showing. but I know
Oh,
she was in a mental health facility for a while.
This was in September. It says September, forensic status review, referral, email, mail to center. And then December. It's the original order.
And so she's just,
the schedule. She was scheduled for January 2nd. Did we get anything? We never got anything.
I was incarcerated in January.
Yeah, but they didn't even send us anything telling us that she didn't show. I don't have
Yeah.
anything after January 2nd.
That's why I was like, I'm just gonna leave this one because I didn't know what was going on.
Someone needs to have follow up with the forensic center so they can send us what their plan was. She's got to get a new referral. What is Mr. Hardy doing?
He's on arraignment. I can see, I can send an email to the principal to schedule her.
Yeah, but she needs to speak to her attorney because does she even still need this is the question.
Well, she's making a client on a probation and this is what he sent me yesterday.
So she's on probation on another file and
Just for,
she's reporting regularly?
I don't know. Well,
So
he has
she's
information about it for
scheduled to
sure.
do what on the 7th?
And take a rise, set to move into one of their homes on 5/7.
You're supposed to move into Rise on 5/7?
Yeah.
Okay, you're all set.
Thank you.
Reset this after 5/7.
Am I ready?
It's gonna just need to be sent to Rise. So that she, go to the address and Rise.
Okay.
And then, she's on probation, she doesn't need a second. Okay. Let's see here. Mr. Riley,
Yes, Your Honor.
do you have Michaela Johnson?
Yes.
This is State of Michigan versus Michaela Johnson, 26-00422. FY appearance, please.
Thank you, Your Honor. May it please the court. Assistant Prosecutor Attorney Dan Smith, appear on behalf of the people.
Jacob Riley on behalf of Ms. Johnson, who's present to my right.
Okay, looks like she pled guilty to an attempted count 1 of the system obstruct. This matter was set for sentencing, but in the interim, she's picked up a bond violation. I have a request, a complaint of a violation of conditional release of custody. The violation alleges that on or about February 27th, 2026, it's 2100 hours, the defendant violated the conditions as follows. Johnson violated section SNU by arriving and being present in the protected party Chance Chandler's home section used specifically states no contact with Chandler, Chance Chandler, or you're not allowed to be within 2,000 feet of wherever he lives, works, or goes to school. And so you have the right to have a contested hearing on that violation. You have the right to be represented by your attorney at that hearing. A violation of your bond conditions, contempt of court issue. Maximum penalty is 93 days in jail and or $7,500 in fine. Do you understand that? How does your client want to proceed on the violation?
She would be, not be admitted to the violation, Your Honor, if you requested it to be contested hearing on that.
I sent this for contested hearing and reset her sentence. You do May 14 at 9. May 14 at 9 a.m. will be the date scheduled for your hearing on the bond violation. Also want to place you on a tether. Your radio security can bring you back up, please, so she can.
Yeah.
She's gotta be remanded for tether.
Oh.
Wait, what? Wait, what?
We're gonna take the assessment, get the tablet and release.
Once you get tethered, you can be released. We'll see you May 14th at 9 a.m. Probably need to switch.
Yeah. Sorry. Yeah. Can you?
Okay, let's see. State of Michigan. This is whom again?
Christopher Johnson.
Oh, that's Mr. Johnson. Mr.
I'm sorry, Mr. Hollins.
Mr. Hollins, Mr. Goodrich, LPD did not have a reasonable response as to why they did not transport your client. So I have to find good cause to adjourn Mr. Murphy because he was not brought over from Rowan County. Actually, I don't think I have to address the timeline. I think that's already been addressed.
Yeah,
We'll
it's
just
been
reset.
adjourned a couple times. already.
Okay, we'll reset that.
Do you have a date now or is it something you're working on?
May 29th at 9:30. May 29th work
Okay.
at 9:30. She can be released after tether.
Okay.
You said this was Holland?
Yes, sir.
Okay. We did all right, correct? All right, let's see. What are we doing with Sierra Dryden and Raymond Pominga?
People are prepared to proceed on that matter.
We're running that?
Yes.
Yes.
Okay. What are we doing with Christopher Johnson? I saw Christopher Johnson's in there. Christopher Johnson's here?
Yes, sir.
Okay. What are we doing with that one?
Your Honor, we'll be dismissing that matter.
State of Michigan versus Christopher Johnson. 26-01036, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith here on behalf of the people.
Jacob Rowley on behalf of Mr. Johnson, who is present to my right.
Okay, this was a motor vehicle unlawful driving away. The people are moving to dismiss.
Yes, after speaking with the victim in this case, the people are prepared to dismiss this case, Your Honor.
Okay, we'll prepare dismissal for you. Do you have any questions at this time?
No.
Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor.
Thank you. Are you waiting for that? You may. Okay, one more time. This is Hollins, correct?
Yes, Your Honor.
State of Michigan versus Isaiah Hollins, 26-00998. And you can approach with that when you're ready, Mr. Smith. And appearances for the record.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
And Jacob Rowley on behalf of Mr. Hollins, who is present to my right.
Okay, today was the date that was scheduled for preliminary examination of 2 counts of police officer assault. Wait, I just say 2 counts. This is Hollins. Okay, and then there's a breaking and entering without entry. Is that correct?
Yes.
Okay, so it says here, the people in men count 1 to attempted police officer assault. It says count 2, but it must mean count 3. He's gonna plead to count 3.
I could plead to count 3 and then count 2 would be dismissed.
Yeah, what this says is amend count 1 to attempt RNO and then count 2 breaking and entering without permission.
So we're gonna dismiss count 2.
Right, but that's not what this says, is what I'm saying. So he's gonna plead to count 3.
Yes.
Okay, and you did write dismissal of second RNO, so that, okay, so I'll just change the 2 to a 3. Okay, and that's what you want to plead to?
Yes, ma'am.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
Okay, you can put your hand down. This is an advice of rights. It's the information sheet. All of these rights you would have to waive or give up if you wanted to plead guilty to the amended count 1 and count 3. I'm sorry, and count, yeah, that is correct. Count 3. You understand that?
Yes.
So that means you're gonna give up your right to be presumed innocent until proven guilty. So you have the right to maintain your innocence and require that the prosecutor prove each element of each of the charges being brought against you. And they would have to prove each element beyond a reasonable doubt. You understand that?
Yes.
You have the right to remain silent at any trial. They can't use that against you. You have the right to see, hear, and question in court any witness that the prosecution calls to testify against you. The right to have witnesses subpoenaed to testify on your behalf, and the right to waive your silence and take the stand at trial if you like. You understand those rights that you would have to give up?
Yes,
Anyone threatening you to give these rights up?
no,
These promises being extended to you if you enter a guilty plea to count, the amended count 1 and count 3.
no.
No one's promising you anything? Did Mr. Riley promise you something? As you looked over at him?
Oh, I was consider, probation I was thinking about,
You was promised probation?
not promise.
Oh, you was just thinking about probation.
It was something,
You were like, I really hope I get probation. You can say that.
I,
Okay, but no one promised you probation?
No.
Okay, and so, are you, you're not on probation now, though, correct?
no,
Are you on parole at all?
no,
Do you have any other matters pending? Criminal matters?
yes.
Okay, where?
In this court, Your Honor, he has 2 pending misdemeanor cases.
Before me?
Yes,
Okay. You understand that a guilty plea could result in the conviction that you may need to report to your current or future employers?
yes,
It also could have impact on where you can travel or get immigration status. You understand that?
Yeah.
What's the status of the other 2 cases?
there's an older case that is set for jury trial May 5th. And I believe also contempt hearing, and then another case, newer case for malicious destruction of property set for retrial that same day.
Smith looked like he was a little surprised.
Maybe if I don't think we have a jury trial. Then
Oh, that's just what I have in my calendar. That could be.
Yeah, I'm
updated.
sure,
I believe it's the 12th. Okay.
12, okay. Yeah.
So pre-trial?
Skipped over jury trial, but I hadn't prepared for it.
It's just pre-trial.
Just pre-trials, no jury trial.
And the content.
And a contempt. Okay, sounds good. Okay, so it sounds like we'll see you soon. As to the amended count 1 of attempted resisting obstructing officer, how do you plead?
Guilty.
And as to count 3, breaking and entering with, entry without owner's permission, how do you plead?
Guilty.
Factual basis, please.
Thank you, Your Honor. Mr. Hollins, on or about April 11th of 2026, were you in, or were you at the location of 4245 West Jolly Road, Lot 11? Yes. Is this in the city of Lansing, in Ingham County, in the state of Michigan? Yes. At that location, did you enter into a home at that location? Yes. Is it true that you do not own that home, were not a resident of that home, and that you do not have permission of the owner to enter into that residence? Yes. Do you also have contact with police at that location on that day? Yes. Were they uniformed, and did you understand them to be police officers? Yes. At some point, were those officers attempting to arrest you? Yes. And is it true that you did not comply with all their demands and that you pulled away somewhat when they were trying to detain you, place you on the arrest? Yes. Thank you.
Any questions?
You were satisfied.
The court is also satisfied with the factual basis. I find your plea to be freely, voluntarily, and intelligently made. The matter is set for sentencing on June 25th at 9 a.m. Prior to sentencing, you will have a meeting with our probation department so that they can prepare a pre-sentence report and advise the court on how they believe you should be sentenced, okay?
Yes, ma'am.
Do you have any questions at this time?
He does not have any questions.
Any additional matters for the record?
Nothing from the people, Your Honor.
We would like to address bond if we could, Your Honor. My client does have those other pending cases that the court is certainly aware of. He has somewhat low bonds on those cases. He has a higher bond on this case. We'd be requesting a PR or a much lower 10% bond possible so that he could have a chance to bond out before sentencing. He has $7,500, 10%.
Yes, how many other matters pending? Two other matters pending.
I've done 60 days for the first one, which is a total of 93 days.
No, but not for this.
Not for this one. They did a mistype up for my first one, and I ended up doing 30 days waiting for the next court date when I was supposed to be out.
Okay, so those other matters were pending when you picked up this case, is what you're saying.
Yes, I stopped by to see my brother and it was notified he's in the hospital. The door was open. I was wanting to surprise him because I just got out after the 30 days that I wasn't supposed to do. So the door was unlocked. I seen people in there and I thought I was gonna surprise them that I just got out. And
Is that that's the address that, of the breaking and entering?
yeah, unlawful entry.
Got it.
Yeah,
Okay, what is the bond in these other matters?
it's a misunderstanding.
One is 2,010%. Other is 1,010%.
Okay, we'll amend the bond to 1,010%. However, we can get someone from probation to evaluate him between now and his next court date. We can, I'll entertain a motion to amend all of his bonds.
Thank you.
We're all set. You're welcome. Is James Ward here?
Your Honor, he's in custody. I believe that he was
Oh,
arrested
okay,
this morning.
got it, sounds good.
2 a.m.
Okay,
I'm not sure if he's here though, or if he's over.
I think he is here. I just didn't see him highlighted, so I wasn't sure where he was.
Okay.
Okay, and we're ready on Dryden and
Yes.
Yes.
Kiogama? Thank you. Okay. I can get set up. We'll call the case in 5 minutes.
All right. Yes.
You running? Dryden, it's, for sure.
We let Judge Simmons know that Judge Ward is now ready for my other case now as well too, so they can decide what they want to do. They both became simultaneously ready.
Which one? Elliot, yes. I'm hoping. You're waiting. We're doing competency referral. And you want to do it ASAP?
That we're on the same page. Just
Hey,
because I
Addie,
looked at the picture and
Can you
never
ask
saw
Judge Simmons if she'd be willing to? So for Elliot, they want to do a competency referral.
That's what we're doing.
And Elliot, he's scheduled last, but just if she's willing to get it out of the way.
Yes.
Oh, God, okay, 1 second.
Yeah. Thank you.
What am I gonna do?
Well, if you look at your picture of Ryan, you'll see that they clearly have mistaken identities.
I don't know. I wasn't there. I wasn't the person who seen it. I wasn't the person who made ID.
Well,
When they get on the stand, they
Yeah.
can say who
Well,
it was.
yeah, obviously.
Yeah, so I don't know.
Well, again, what I do know is they provided pictures of who it is and it ain't who it ain't.
Hey, Ed, I'm going to email Tracy and have her send out the subpoenas for Officer Driggs and then it's chance to there directly. So I'll CC you on it.
What's who?
The one that was supposed to be second.
So what are we going?
I don't really know what to wait. One of the odds that both courts become available at the same time.
Happens every time.
Murphy's Law.
She said we're gonna do this one first.
Okay.
That one, I got it.
Yeah.
Yeah, yeah.
Still,
Yeah.
and the hearing is on 14.
I think for purposes may set up over in the jury box.
Awesome.
Yeah. No, just wait, you wait right now, it's up, officially on the case. Okay. We'll let this. Robinson had her first cheer since she's got the preparation here.
I don't know, I just assumed as much. I don't know. You can be seated. I am unclear why in the world I have all of these partially used. This was supposed to be continued until May 21st, so I can't throw that one.
Need a new one?
Well, I don't think it's that I need a new one. I'm just trying to make sure I'm not supposed to be saving these.
Oh,
And some of them were continued to 7 days, and some of them I know I'm not supposed to be saving. All of these are almost gone. Like this was supposed to be February 13th. If we ain't finished, it ain't getting finished. I just need to go through this, because all of these are like. What is your? Yeah, I got some exhibits. Okay. Separate or together?
Yes.
Okay. Well, like A, B, C, D,
Yeah.
okay.
That's fine.
oh,
Oh, thank you, Ed, for sending that.
Oh, I'm like, what?
Well, because I gotta send in one of them, girl. I'm like, girl, what's your name? Michaela. Okay. You can see how the slip look. I don't know what I was.
It's all over the place.
She said, "Am I going home?" No, you gotta get a tether on. And they want to send her out to Mason. She can't even get it yet. Okay, so tether on. Okay. All right.
Mr. Barry has a homicide?
Yeah.
What is your plan?
I was told that you made the determination that we run this one.
Oh, I called. How was I supposed to know you had a homicide? I don't know your schedule. I called the case. I didn't make a determination that we were running this one. I called the case, and then after I went to go put some coffee in my cup, I was told that you had to be over there as well.
The information I was given, whether correct or not, or at least I understood it to be, is that you had proceeded with this preliminary examination because Judge Ward's is going to be all day, and so we'll be doing this one first.
Somebody.
I was leaving it to the courts to decide how to handle it. Obviously, I'm not going to tell the courts what to do.
Well, you can't be in both places, so you're gonna have to make a motion to adjourn one of them. If you, because I called the case.
Okay.
So if you can't be here because you have to be there, then you gotta move to adjourn.
I've been told that Judge Ward knows and will be waiting for us to finish this one as well.
That's up to you. She just came to see what was going on. I think they're waiting for you, so.
Okay, well then I'll go find out from Judge Ward then.
She's already came. You can call your
I'm just
first,
trying to please as many people as I can.
you can call your first witness.
Mr. Keo. Yeah. Okay.
Oh, James. Sink.
Solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, I do.
Okay. Just state your first and last name and spell both.
My first name is Jacob, Jacob. My last name is Sink, S is in Sam, N is in Nancy, K.
Okay, thank you. You can proceed, counsel.
Thank you, Your Honor. Morning. Well, it's been quite a long morning, but hopefully we'll get you out of here pretty quickly, all right? James, are you currently employed?
Jacob.
Okay, Jacob, I'm sorry.
Yes, I am.
And where are you employed?
The Board of Water and Light here in Lansing, Michigan.
And what's your job title?
Physical Security Specialist.
And how long have you been in that position?
3.5 years.
Yeah. And can you just describe some of your duties as you're currently employed?
Yes, my duties as Physical Security Specialist are maintaining the physical security of our assets, fencing, lighting, responding to calls for service from our field crews to assist them, making sure that our facilities are secure.
And I'm gonna direct your attention to July 2024. I know it was a couple of years ago, but were you operating your capacity on that day?
Yes, I was.
Did you happen to engage in a larceny report on that day?
I did.
All right. Can you tell the court how you come to report the larceny?
So I believe I arrived at work that morning and our maintenance supervisor from our dye water facility, which is located at 148 South Cedar.
Is that in the city of Lansing?
City of Lansing County.
County of Hingham, state of Michigan?
State of Michigan.
Okay.
That they had observed some copper cabling or wiring that had been cut away from some equipment that was at that facility. And so I began looking at our camera footage in that area. I was told that that equipment was on the north end of our dye water facility. And that butts up to it's kind of an alley, but it's J Street. And so I started looking at our camera views in that area.
And your camera, is this a camera that's normally covering this portion of the facility we're at?
Yes, sir. At at the Board of Water and Light, we have a large volume of cameras that cover our facilities, and that is contained within our security department where I'm part of that team.
And are those kept in the normal course of your security business?
Yes.
And do you have access to those cameras as a
do.
security guard? And you access those cameras in relation to this incident?
Yes.
Okay. So after you originally saw what you reported as a larceny, what took place then?
So after reviewing the cameras, I observed the day prior, two subjects on bicycles come down Bay Street, and on video, one of the bicycles had a small bicycle trailer attached to the back of it, and one subject climbed our locked and secured fence. I believe it was three rows of barbed wire at the top. They threw something over it, and they climbed over into our facility. A few minutes later, copper wiring was being passed through the fence, and the other subject loaded it onto a trailer on one of those bikes, and then they left the scene. After that, I created a bulletin for our guard staff with snapshots. I also took some snips of the two subjects and responded to two different scrap yards in the city of Lansing.
And do you remember what those scrap yards were?
I believe they were Friedlands and Padnos, both in the Lansing area.
And describe what took place after you responded to the two scrap yards.
So responding to the scrap yards with those snapshots, I showed the employees those snapshots of the two individuals and asked if they could identify them. I don't remember who I talked to. An employee at one of them, I believe, said that.
Objection hearsay.
You want to respond?
Effective listener.
He's going to tell us what he did next, or
As a result of hearing what he found out.
okay, I'll hold your objection in abeyance while I figure out where we're going with this.
Thank you.
I showed those snapshots to the employees at those facilities, and I was provided a name.
What name were you provided?
Raymond Kioma. Raymond Kioma. I believe that's how it's pronounced.
Okay. And do after you provided the name after you provided this name?
Working in my capacity, given the theft that occurred, I filed a police report with the City of Lansing Police Department. I was contacted by a detective after that, and I provided the City of Lansing with the video of the larceny and the information that I had.
So,
For the record, I'm going to overrule her objection. You can continue.
And the information that you provided was what all does that include?
I believe I advised the detective that I had responded to those 2 locations and that I was told the name that I had previously stated.
Were you provided the name of a female suspect?
I was not.
Okay. And in your report that you turned over to Detective Hackenberg, did that include snapshots of the individuals who were involved in the larceny?
As I recall, I provided him with a bulletin that I created for our guard staff. Because of my capacity, I want to make my guard staff at all of our assets, all of our facilities aware that this had occurred and to be on the lookout for them. I believe I provided him with that bulletin and also the video evidence.
And do you remember what specifically the items were taken?
As I recall, it was copper wire.
And what was the condition of this copper wire?
I don't know.
Okay. Was it, do you know if it was new, if it was used, or?
I don't know.
And did you make anyone else in the company aware to you, aside from your security staff?
So I worked in conjunction with the Dye Water facility, the maintenance supervisor, his name is Justin Fry. And he had more details as far as the equipment involved.
So the individual who you come to identify as Mr. Yelmer, do you know that person individually, personally?
I do not.
And did you know anyone that you saw on the videotape? Were you able to identify them?
No.
From your personal knowledge?
No, sir.
Did you have any other involvement with this investigation of the larceny?
No.
Thank you. No further questions.
Cross-examination.
Mr. Sinky, correct? Sink, sorry. I see the E at the end.
That's
I want to say it.
Very common.
All right, so you're in charge of security at Board of Water and Light, is that correct?
I'm a member of that team, yes.
Okay, and in part of your jobs as doing security, you're in charge of looking at security footage, maintaining security cameras, correct?
Yes.
Okay, and you stated that on the date of the alleged incident on July 14th, I believe of 2024, you were notified of this incident, correct?
No.
No, it was the day after?
I believe it was the day after.
Okay, so the day after you were notified of an incident, and then you went to go check your security cameras, correct?
Yes.
Okay, and you found what you believe to be footage of the alleged incident, correct?
Yes.
Okay, and I'm going to show you. This was not previously marked because I assumed that people were going to introduce it, so I apologize, Abby. I'm going to show you a still. Do you recognize this?
That looks familiar, yes.
Okay, can you tell me what it is?
That is a camera view from one of our cameras. That is on J Street, where I spoke of earlier.
Okay, and is this a footage of the alleged incident that you have testified to here today?
It's a portion of it. It's not footage. It's a snapshot or whatever.
Your Honor, I'm going to ask that this be admitted as defense exhibit. Ooh, it's already on.
Okay. No, that's a lot. Oh, she had some already. Got it.
On defense exhibit I, since.
No objection.
Right, now I'm going to play the video for you.
Okay.
No objection from the prosecution?
No.
Okay, defense eyes a minute.
Judge, can you see it?
Barely.
Yeah, I don't know.
I can scroll.
Is this a video or?
Yes, this is
Okay.
the video of the security incident. There's no sound. So I'll pause it right here.
Okay.
What do you see in that video so far?
I see what I described earlier, two subjects coming down the J Street and one subject climbing our fence into the Dyewater facility.
And both of them are on bicycles, correct?
Correct.
Okay, and there's a female involved in this incident, correct?
There's a second subject. Yes. And there's
Person with blonde hair.
person with blonde hair. Yes.
Okay, looks like long and in a ponytail.
If I had to make a guess, yes.
Okay, do you see any tattoos on that person?
I would object. I haven't seen the video yet, so
You provided the video and evidence.
I need to see what he's saying on.
Can you log in and put it up there, please?
Yes, I'm not sure how to do that, like.
Just log into Zoom.
Oh, into Zoom,
And
okay.
share, yeah, and then I'll give you permission to share your screen.
Just for matter for the record, this is just simply the surveillance video we received. from
Correct,
Saturday,
yes,
right?
yes.
It would help me though, because I'm
I
trying to see
understand.
down there.
Just making a record for the prosecutors, indicating it's not reviewed.
I said I'm not seeing what he's saying, so I can't. So I'm not objecting to the admission.
So sharing is not turned on. Okay, so you can see, can you see this clearly?
So now I would object to that question.
Yeah, but the question was whether or not she saw, you can see tattoos?
Yes, does this person have any tattoos? Do you see this person have any?
Are you objecting to what?
That's the question. I don't believe it's based off of that view of the video, anyone could respond.
She actually.
I'm looking at it. I can respond,
Okay.
but I don't, but I think it probably was easier for him to see from there than from there. I would allow her to bring that back here. You can see it from there, but he can see that easier from there. Because I'm seeing it on my screen.
I'll reapproach.
It's too small there.
Okay, yeah.
do you see any tattoos on this individual in the blonde in the video?
Maybe. I can give a definitive answer to that.
Okay, let's keep watching then. We'll keep watching the video and you can let me know if you ever see a tattoo on this individual.
Can I just speak up?
Sure.
When she came around here, maybe on her left arm. If it is a tattoo.
Maybe one on the left arm.
Maybe. Never even looked at that.
Besides
I see
the one,
something on her left arm.
possibly something on the left arm. Besides that, do you see anything else?
Not that I see.
Now, you stated that you created like a bulletin or a be on the lookout for the people that were in this video, correct?
Yes.
Okay, and you used still shots from this video?
Correct.
Okay, and you sent that to police officers?
The
police?
The bulletin is created for our guard staff, who is a contracted guard staff. Our facilities, we do get repeat offenders that come back. So I wanted our guard staff aware of what happened and the photographs. I believe the actual bulletin was presented to the detective in this case.
Okay, so you sent that to staff of your facility as well as the police, correct?
Correct.
After doing that, did you have any other involvement in this case?
Other than going to the two places?
Correct, after you went to the recycling and sent it the.
Not that I can recall.
I'm also going to show you some still shots from the video that I've previously been marked as Defendant's Exhibit G and Defendant's Exhibit H. If I can approach, yes. So can you identify what these are?
I believe these are from my the security video that
Okay, and what did they show?
they show a subject wearing top and black. This would be what we talked about earlier, the possible female that was there.
Okay, and that these photographs fairly and accurately depict the woman that we saw in the footage, correct?
Yeah.
Okay.
Yes.
Your Honor, I'd like to move to admit these into evidence as Defense Exhibit G and Defense Exhibit H. Any objection?
No objection. I just need to answer.
Yeah, no problem. They're just blown up.
Perfect. Thank you. No objection.
Here a minute.
And I have no further questions at this time.
Mr. Sink, did you ever receive any documents from your pre-clinical diagnosis in regards to the investigation on this matter?
Not that I can recall.
Okay, so you never saw any still shots or surveillance of any body scrapping in after?
Not that I recall. I think my initial, I'm sorry.
I have no further questions.
Can you just play that video for me one more time?
Yes.
Okay, thank you.
My apologies. May I ask another question? So, Mr. Seaton, you met with both those facilities on July 18th, correct?
Don't remember.
Okay, but very shortly after the incident occurred.
Very shortly.
Okay, and you told them the date that it occurred, correct?
I don't recall what I told them.
Would you have told them that it just happened within the last couple of days when you met with them?
I would imagine, yes.
No further questions.
There's a couple questions. So the pictures that you provided to the two recycling centers, were they the pictures that you were shown by defense counsel?
I don't recall what pictures I actually showed.
You showed them. But the individual from the recycling center identified the two individuals.
Objection, Your Honor, hearsay again. We've already established that the purpose of the allowable purpose was to determine what. It's clear that the prosecution is trying to circumvent the rule.
I'm not sure what the ruling was.
It was
Effect on
the listener, so I allowed it for that purpose. For his response as to the people from the recycling, what is it? Scrap yard allowing or identifying whoever identified. My understanding is that that was being offered for the effect on the listener, so you can understand why he turned this information over to the police.
So, yeah, so after the two people were identified, you turn that over to the police, right? The names of the individuals that were identified on from the snapshots that you provided.
That's incorrect.
What happened?
One person, I was given one name.
One name, okay.
Not two names.
And they were able to identify that based on the snapshot you gave.
I don't remember which place, if one or both of them did, but I was provided a name of that I stated earlier, as that they knew who it was.
Okay, all right, thanks, no further question.
Okay, this one is the excuse. Thank you.
Thank you.
Our next one.
People called AJ Manor.
Is it okay if I stop sharing?
Oh,
so I can
yes.
take notes, please?
You saw, you're gonna raise your right hand. You actually can go right to where you're gonna step up
Okay.
and then raise your right hand. Okay, do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? You can have a seat.
Thank you.
No problem. And there's a microphone that's gonna be in front of you. The purpose of that microphone is so that the lady behind you can hear everything stated in the courtroom. So all of your responses must be verbal. No head nods, head shakes, okay?
Okay.
If there's an objection, you'll stop speaking. I'll make a ruling on that objection, and then I'm going to advise you if you can give us the answer to their question or not. You just state your first and last name and then spell both of them.
First name is AJ. Last name is Manor. Spelling of the first name is AJ. Last name spelling is MANNOR.
Thank you. Proceed.
Morning. Last time we talked, you were moving, right?
Yes.
Did everything work out? Or
Yes,
still-
yes,
Okay,
yes.
great. So let me just talk to you about what brings you into court today. I'm gonna direct your attention back to July of 2024, all right? At that time, where were you employed?
Yes.
And where were you employed?
I was employed at Padnos Recycling Center.
And what were your duties at Padnos?
My duties at Padnos, I was the CSR, so I would weigh in customers, weigh out customers, and then pay them out at the end for the material that we.
Okay, and how long had you been working at Pat Nose in July 2024?
I would have just reached my 2 years.
2 years?
Yeah.
And are there, so we're gonna, again, we're talking about July of 2024.
Yes.
Are there individuals seated in the court today who you recognize from that date?
Yes.
Can you identify each of those individuals and describe the article of clothing?
Yes, I recognize Ray, who's in the light jacket there, and then I recognize Sierra.
And how do you recognize those individuals?
They were pretty regular peddlers, which is what we call people who come in on the main street of our businesses and drop scrap pretty regularly, regularly.
So when you say regularly, just give me an approximate time. How many times approximately did they come into your location?
Ray, I would say, was probably in a couple times a week. Sierra, maybe a little less than that. Maybe like a couple times a month. I think I would remember that.
Okay. And I'm going to direct your attention to about July 23rd. Were you approached by a detective from the Lansing Police Department?
Yes.
What was that in relation to?
That was in relation to some non-ferrous material that at that point in time they were interested in, who had dropped it, and all.
Did Detective Hackett, this detective, did they give you an idea of where that material came from?
Upon the first visit, no. They were mostly just interested in IDing the material first, and then they had come back in and explained the situation.
So, based off of what was explained to you, don't say anything that anyone said. What was your understanding of why police were looking for this material?
It was my understanding after the conversation that that was material that was stolen, basically, or was not given to the individuals. And that was kind of the summary for that.
And did you get an understanding of where this material was stolen from?
Yes, they did let us know that it was from BWL.
And that's the Board of Water and Light?
Yes.
And through this interaction with the detective who came to speak, were you able to, what involvement did you have with that investigation in identifying those people?
So they came back in, they asked who had dropped that material. So my job was to run back the cameras, which we have in our non-ferrous building all over the yard as well. And basically get screen grabs from the material being dropped. That was it.
Okay. And in your position with the company, is this footage that's normally kept in the ordinary business?
Absolutely.
And then you have the ability to run that camera footage back?
Yes, correct.
And did you specifically identify the items that were dropped off or alleged to be stolen?
Yes, once the detective had confirmed that that was the material that they were interested in, that is when I looked up who had dropped it.
And based off that investigation, who were the individuals who had dropped off that material?
Based off the investigation of that, that would have been Ray, Fiona, and Sierra driving.
And how do you know it was those two individuals?
Based off of what the police officers and what the detective had provided as far as the material, pictures of the material that had been taken, that was matched, like I said, with the material that was dropped. And then from the cameras, we see who was weighed in. We take pictures of everybody with their material on the scale. And that's how it was able to be.
In the course of your job, do you keep identifying information for the people who drop off scrap?
Yes, in the state of Michigan, it is law that if you are dropping the scrap, you do have to have a valid ID on file. So we always have a copy of the peddler's IDs, as well as, generally speaking, if they have a vehicle, we will have all of that information in the profile as well.
And did you provide that to police?
Correct. That is what I provided, was a copy of the ID as well as pictures of the screen grab from the scale.
You said pictures of what?
The screen grabs of the scale.
And did you view screen grabs taken from the Board of Water and Light?
That was not on our end, as far as, I guess, what they might have provided. We saw what they had provided to the detective. So that would have just been whatever picture that was.
So the detective brought in these pictures and you helped identify them?
Correct, yes, correct, yeah.
So, okay. Do you recall the amount of the product that was scrapped?
I do not recall the exact amount. I want to say it was in the ballpark of 10 pounds, but again, I don't remember.
Okay. And was this particular interaction with the two individuals who you identified, was this unique?
It was out of the ordinary for the grade, I guess, of the material, yes.
Why was it out of the ordinary?
What we consider to be bare bright or number one is a harder copper to come by because it is generally only used for like construction, new builds and things of that nature. So that is a non-ferrous material that we are prone to flag if a lot of it comes through, no matter really who it is.
And what was the quality of this? Do you remember the quality of the product?
I believe we graded it as number one, if not bare, or a mix of bare bright and number one.
What's number one?
So number one is just a step below bare bright. Bare bright is copper that has never been used and clearly has not seen anything. Number one is just right below that in the sense of it. I guess I'm not the non-ferrous person, so from my understanding, it's just slightly under what bare bright is, and then we probably graded it that if we graded it number one, because that's what we would be selling.
So was you're gonna have to break this down for me because
Sure.
I have no idea about this bare bright.
Sure.
So was this like new? Was like new stuff, used stuff, or how would you describe it?
So unfortunately, I was not out in the building and I only saw the pictures, so I can't really say if it was ever used, but I do know it was not, it did not look like it had been used.
So, can you talk specifically about the amount? Was the amount, was that unusual? Or the weight?
The weight was higher than what usually, if I remember correctly, on most transactions, it is about 2 pounds, 3 pounds. But I also know that that tends to correlate with the fact that we only allow cash for a certain amount of copper, and the rest has to be checked. So a lot of people kept their copper under certain amounts so that they would not get a check.
Mm-hmm. In this case, do you remember whether or not they got a check?
I do not recall, unfortunately.
But it was, you said about 10 pounds.
I believe so, yeah.
Which
would have required a check to be sent.
Right. Which I think you indicated was unusual for these two scrappers to bring
Yes.
that amount
Yeah.
of copper.
Right.
Um, And did you have any other involvement in the investigation after you identified them and turned over that information?
Not until Detective Hackenberg had reached out in at the end of March to let me know about the proceeding.
Oh, okay, yeah, I think I had him give you a call.
Yes, yes.
About it. So, outside of your scrapping job, do you know these two individuals personally?
No.
It's do you still work at the at that location?
I do not. No.
Okay. So yeah, I think that's all the questions I have.
Cross examination.
Okay, Mr. Manner, so you were working at, I think you said Padnos, correct, in July of 2024, is that correct?
Correct.
Okay, and you were approached one day by detectives around, let's say, July 23rd of 2024?
Sounds about right.
And they asked you to look basically at your security footage to see if anybody came in scrapping basically good quality copper.
Correct. And I believe they had provided a picture of one individual that they were interested in that day.
Okay, so you looked through the footage, correct?
Correct.
And then you stopped at two people.
Correct.
Okay, and you identified those people as Ray Kyogama and Sierra Dryden, correct? From the footage in your security camera.
Correct.
Okay, so you were told by the detectives what sort of material they were looking at, correct?
Yes, correct.
Okay, and you said it was higher quality copper, correct?
Correct.
And they came in and you were looking for higher quality copper that was scrapped around this time period, correct?
Correct.
And you stated that you've identified the two people that came in to scrap this copper as Mr. Kyogama and Ms. Dryden, and they've been to your facility before.
Correct.
And besides that, so basically what you told detectives that day, just to sum it up, is that from the footage from your facility, you identified Mr. Kyogama and Ms. Dryden as two people who scrapped high quality copper around the time of the alleged incident. Is that correct?
Correct.
Nothing further.
Prosecutor.
Thank you. You provided some documentation to the police as well.
Correct.
In fact, the documentation you provided to the police shows that the last time that we refer to as Ray, that individual, the last time we had a transaction for him, in fact, would have been June 10th, 2024. Is that correct?
Unfortunately, without seeing the record.
Okay, we're showing you that scale receiver checking, itemized, help you to refresh your memory.
Sure.
Is that the same?
You're looking at Sierra. And we're looking at
Okay.
Your Honor, may I show the witness? Okay. So how this works procedurally, sir, I just ask you to look at it to yourself to refresh your memory without saying anything. Let me know once your memory is refreshed if it is.
Okay.
Does that?
I mean,
No, sir. Again, procedurally, you just let me know after reviewing that if that helps refresh your memory.
not really.
Looking at the actual copy of the document you provided law enforcement as to the transaction by Raymond Kyogama does not help refresh your memory as to what you provided to law enforcement. Is that what you're testifying, sir?
I didn't provide them a printout of that. I provided them pictures.
Okay. Did you review the documents and provide receipts of transactions to police?
No.
Okay. So you're unaware of the receipts for transactions that were provided to police?
Correct.
You weren't involved with it?
That could have been my boss.
Okay. So did you provide the police any still shots from surveillance of transactions you believe that could have been related to this matter?
Correct.
Okay. And again, you provided them still shots of Mr. Kyogama from June 1st, 2024, didn't you?
I believe so.
Okay. Did you provide, and so would reviewing the still shot help refresh your memory?
Sure.
Okay.
Okay.
Okay. So is it in fact true that you provided them a still shot from Mr. Kyogama at the scale or whatever from June 1st, 2024?
Correct.
And just to be clear, that is from your
Non-Ferris whereas, yes.
Okay, gotcha. And gave them different angles from your store on June 1st, 2024. Right?
Correct, yes.
You didn't give them any pictures of any surveillance video of Mr. Kyogama. Excuse me, let me go one more. There was another one from June 10th as well, right?
I believe so.
Okay, and then seeing you help refresh your memory?
Sure.
Did you see that?
Correct. Yeah.
And there's a still shot for Mr. Kyogama at your location on June 10th, 2024, right?
Yes.
And that coincides with the receipt from June 10th to 2024 that somebody else may have provided, but that you didn't.
Correct.
You've not seen any receipts or transactions or provided any pictures of Mr. Kyogama in your facility after the date of June 10th, 2024, did you?
Not to my.
Okay, so when we talk about these pictures, right? You provided pictures of this other individual from July 16th, 2024 at your location, right?
Correct.
And that's this person with this blonde hair in this picture, right?
Correct.
And that you believe, or that had the account at least of this Sierra individual, right?
Correct.
And your belief, you're at least trying to identify, or maybe I'm mistaken, you've said Sierra, is that blonde? Are you trying to determine, do you know for a fact whether that's the same individual or that's just the account that was used?
So by the account that was used as well as the individual that was.
Yeah, yeah. So anyways, but you weren't there that day, right? Where you weren't on the floor.
No, not in
You're only
non-Ferris.
going back post hoc afterwards and trying to look and review it, right?
Correct.
But you are familiar with Sierra and Ray being familiar with each other, right?
Not really, no.
No? Okay, so you don't think of one name and then think of the other?
No.
Okay, so if perhaps, somebody's identifying one or the other, it doesn't necessarily mean anything to you that it implicates the other.
No.
Okay, good. And so, what pictures were you shown by law enforcement in this matter?
I believe it was pictures of.
Let me clarify, because it's very important when you testify from personal knowledge. So when you say, I believe, that could be your way of mannerism and speaking, or it could be guessing. We don't want you to guess or speculate. I need you to know. What do you know that you saw in pictures from law enforcement?
It was a type of wire, type of copper wire.
Showed you a picture of a type of wire.
Yes.
What did it look like?
It was like utility wire is what I would describe it as.
Okay. Now, the transaction from July 16th was copper tube, correct?
Correct, but.
How long of a
that's just
piece of a
an
copper tube would be a 3-pound weight?
That long could be, like 6 inches maybe?
Okay, were you aware that the alleged stolen material in this matter is actually a rather large reel of copper wire?
In its.
How many
form.
feet of
You have to
wire?
allow, no, you have to allow him to answer.
I apologize, go ahead.
Yeah, in its original form, yes.
Yeah, how many feet of that copper wire would it take to produce 10 pounds?
That's really not my area of expertise, unfortunately.
You can say in reviewing these pictures that from that July 16 transaction, that the material that was produced that day and
Correct.
paid, I think, $32, right?
Correct.
Is not copper wire constituting 10 pounds of wire, right?
Correct.
So that would not be the same type of material.
As far as the grade, it could be, but
Got
again,
it. Okay, what did the picture look like of, you said you were shown, I believe I'm going to try to quote you as best I can, whatever photo they had of this individual suspect, right? Can you describe what it looked like?
it was, like you said, kind of a thicker wire that was.
No, I apologize. I said suspect.
Oh, the suspect. Unfortunately, I was not the one that weighed it in, so I only know what I saw on the screen.
Okay, so when law enforcement showed you a picture, you don't remember exactly what that picture looked like of that individual?
Oh, the picture of the person, not the
Yes,
material.
yes.
Yes, I do.
Okay, what did that picture look like of that individual?
So the picture they had was of Ray Hume.
Well, again, I'm not asking you to make a conclusion. I'm asking you to describe what the picture looked like. What do you remember about the picture?
The picture was of a man on a bike, and he was, it was kind of like a side profile picture, I guess you could say.
Okay.
3/4 profile.
Okay, so there was a picture
Yeah.
that was taken
Yeah.
and shown to you,
Yeah.
and essentially they come to you because this involves some kind of scrapping and asking, who does this look like, right?
Yes.
You would agree that that picture was zoomed in and rather grainy.
It was zoomed in, yes.
Okay,
Yeah,
and grainy, correct?
sure.
To the difficulty that facial features were not quite clear, right?
Not
Basically, sir, I'm
recognizable.
asking you, how well do you know Ray McKeown?
Again, just from work,
How often did he come in?
a couple times a week usually.
Okay, for how long?
From when I was there, regularly, a couple of years, so
Okay.
2 years.
So when officers showed you a picture, they didn't show you any kind of six-pack lineup or anything like that, right?
Correct.
Okay, so you're thinking along the lines of, who do I know that this could be or who this could look like, right?
Correct.
Okay, and so basically what I'm asking you, sir, is, would you agree that you might be wrong?
There's always possibility for doing it.
Thank you. I have no further questions.
Start reading it.
Just briefly. The defense counsel asked you on cross-examination, was there a receipt of items that were taken? And he asked you the last time that Mr. Kyoto had a receipt was in June. You remember that? You remember that?
Yes.
Okay, I'm gonna. You said that other receipt, if those receipts weren't provided by you.
Correct. Yeah.
Give me a second here. I'm gonna show you a receipt.
Sure.
And ask you if this is a receipt from your from your company. Can I approach you on?
Yes.
Which one you show? It's gonna be the one from
716.
Yeah. Perfect. This is a, did you want to see that? Councilman? This is a receipt. Can you give me what's the date on that?
That is July 16th of 2024.
And that was shortly after the alleged
Correct.
Theft took place at the boardwalk, right?
Correct.
And whose name was on that receipt?
On that receipt, that was Sierra Drive.
No further question.
May this witness be excused?
Yes.
Thank you, sir. You may be excused. You can call your next witness.
We're gonna call Jake. No. Scott Tyler. We'll pay your part. So what you're gonna do is you're gonna stand right there where that chair is. The judge is gonna swear you in, and then you're gonna have a seat.
Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, thank
You
you.
can have a seat. Okay, there's a microphone that's in front of you. The purpose of that microphone is so that the lady behind you can hear everything through the recording system. It will not amplify your voice. So we need you to keep your voice loud and clear. All of your responses must be verbal. You can't do head nods, head shakes, and uh-huhs, okay?
Okay.
State your first and last name and spell both.
Scott Tyler.
Spell both.
What's that?
Spell them both.
SCOTTTYLER.
Thank you, Your Honor. Mr. Tyler, I know your meter is about to run out, so we'll get you out of here as quickly as possible, all right?
Yeah.
So I want to, Mr. Tyler, let's start off by, can you tell me are you currently employed?
Yes,
And where are you employed?
I work at Friedland Industries.
And what does Freeland Industries, what does that company do?
It's a recycling facility.
And what is your title there?
I'm the scale operator, scale manager. I run the truck scale.
And so the truck scale, what duties, or tell me what your daily?
We weigh in trucks or bicycles or whatever people bring across the scale to sell their product.
And how long have you worked at that location?
I've been there a little over 3 years.
And I'm gonna direct your attention to July of 2024. Were you working at Freeland at that time?
Yes, I was.
Did you happen to see anyone here in court today that you recognize from the July 2024 time?
Yes, I did.
Can you point that individual out and describe an article of clothing?
Ray Killigan.
Your Honor, let the record reflect that the witness has identified Mr. Kyoto.
Any objection?
Can I ask you to repeat the last name?
I can't pronounce it real well, but Kiog is how I always wrote it up on the computer.
No objection for the names of which.
Identification included.
Okay, and in July of 2024, how often did the Ray come into your your location, describe
He used to ride in quite a bit on his bicycle.
on the bike. Was there anything unique about that bike?
They had a little cart.
Cart on the back?
Yeah,
Okay.
hooked his back in it.
Okay. And so when you say he came in often, how often? Would it be like a couple times a week, once a month, or?
Sometimes it'd be a couple times a day.
A couple times a day? Okay. So would you say you had a pretty good idea of what he looks like?
Yeah.
Okay. So I'm gonna direct your attention to about July 23rd. Did there come a time, July 23rd, where you participated in an investigation of theft of property?
I had a gentleman come in from the Border Water and Light and showed me a picture of a person and showed me his credentials that he was security with Border Water and Light. And I identified the picture of who he was.
Okay, so the Board of Water and Light brought in a snapshot of an individual, right?
Yeah.
And they said that individual, what did he tell you about this situation? Why was he coming?
They had stolen material from the facility.
And he gave you a snapshot of that individual?
Yes.
Right? And based off that snapshot, you were able to identify him?
Yes, I was.
Tell us how you were able to identify him.
I just looked at the picture and I knew from previous dealings and who it was.
And who was the individual that you identified in that snapshot?
Right.
No further questions.
I have no questions for this witness.
Thank you. Sir, were you shown any video by anyone?
It was on his phone, I think it was, that showed me the picture of it.
So you were shown, okay, so this Board of Water and Light representative had a cell phone, right?
I think it was a cell phone. We're talking 2 years ago and I've dealt with a lot of people since then.
I understand that. So you're saying it could have been on paper?
I don't think it was on paper.
Okay, so
I do believe, I think it was on electronic.
believe you think it was on an electronic medium?
Like I said, sir, that's like 2 years ago and I had a hard time remembering what the case was.
I understand, but you're certain it was a picture and not a video, right?
Yes.
So you would agree from that picture, were you showing multiple pictures or just one?
No, just one.
Just one?
Yeah.
So you weren't able to look at the mannerisms or the body movements or anything like that, right?
No, I just seen it.
You weren't able to hear anybody speak?
No.
See how someone walks or moves their body, right?
Nope, I just seen a picture of his hands.
And could you tell, I mean, how large was this image? If you can't, it seems like you think it was on the cell phone, so was that rather small?
It seemed large when I looked at it.
Okay, so are you saying that it's not a cell phone then, or are you saying that a cell phone picture would be large?
It could be large. You could blow it up and make it bigger.
Okay, so my cell phone right here, I zoom in, right? We'd agree that that loses some clarity in the photo as we zoom in, right?
All depends on what type of cell phone you have.
Sure.
A lot of them have.
Do you like Mr.
clarity.
Kyogo?
Huh?
Do you like Mr. Kyogo?
Yeah, I dealt with him. He was fine.
Okay. You wait till I finish the questions before you try to, so the image, what can you describe without drawing a conclusion as to who it was or whatever it was? What do you recall seeing in the picture?
I recall seeing him.
What else?
I think it was, no, I'm not gonna say because I just recall seeing him.
Okay, so again, you were confronted by somebody showing you a picture, telling you that it's in regards to, theft of copper, and that's something that you come across often in your line of work, right?
Yeah.
And asking you, who might this be, right?
Correct.
You're not saying for certain that's what it is. You're suggesting someone who you believe it could be, right? Power of suggestion is powerful. You agree with that, right?
Yes. Yeah.
And you could be wrong, right?
Probably could be, I
Okay,
guess.
and you didn't see the actual video or a perfectly clear image,
No,
and you don't even recall necessarily the scenery or what kind of context the picture was, right?
no, not from 2 years
I
ago.
believe, thank you, sir.
Yeah.
No further questions.
No question.
Thank you, sir. You may be excused. We have the witnesses.
Got one other witness. We call Justin Bray.
Do you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I swear.
Please have a seat. Okay, there's a microphone in front of you. The purpose of that microphone is so that it can record your responses for the system. It's not going to amplify your voice, so if you can keep your voice up, that would be wonderful. All of your responses must be verbal, so if you do head nods, head shakes, or mhm, we'll have to ask you if that's a yes or no. And then if either of the attorneys, and there's an attorney sitting over there too, if any of them said objection, you'll stop speaking. I'll make a ruling on that objection and tell you if you can give us the answer. Okay?
Yes, sir.
If you could first state both your first and last name and then spell both of those.
My name is Justin Fry, Justin Frey.
Okay, you can speak up.
Thank you, Your Honor. Mr. Fry, it's been a long morning, so we're gonna try to get you out of here in time for lunch, all right? Are you, where, are you currently employed?
Yes,
Where are you employed?
I work for the Lansing Board of Water and Light. I'm the maintenance supervisor for water production.
And how long have you worked in that capacity?
I've worked for the Lansing Board of Water and Light for 3 years.
Okay. And were you working in that capacity on July of August of 2024?
Yes, I was.
Okay, can you describe your what you do as a maintenance operator?
I'm the maintenance soup, so I have multiple skilled trades, electricians, instrumentation controls, mechanics. I'm in charge of the well field, 125 wells in the greater Lansing area, 2 water plants, and 5 booster stations. I maintain those facilities maintenance wise.
Okay. And I want to direct your attention to why we are here today. So back in July of 2024, do you recall there being an incident of a theft of copper from the Board of Water and Light?
Yes.
And how did at some point did you become involved in that investigation?
Yes.
And how did you become involved in the investigation?
My union crew leader notified me that the cable on our submersible pumps that skidded for some well sites in the city were missing, and they were inoperable. For budget purposes, I had to report that up the chain of command that some pumps were inoperable at the moment, that we had skidded outside for work.
So when you say inoperable, what made these pumps inoperable?
So they go in the Saginaw Aquifer several hundred feet down. They are a contained casing. So if you cut the cable too close to the pigtails, you have to tear apart the submersible pump, which vetoes the warranty, and also it's not a guarantee that those pumps will perform after I spend the labor hours to put them down.
Okay, so I'm an attorney. I have no engineering background at all, so you're gonna have to break this down to me a little bit. Okay, so when you say they were inoperable, did someone come into the place and damage these pipes?
Correct. Yes.
And to your knowledge, how were these pipes damaged?
For correction, Your Honor, I think we can clarify, I think there's mischaracterization saying pipes. I don't know if that was the.
You said pipes, a mischaracterization saying pipes is what you said?
I believe so.
What was it that was damaged?
They are pump motor combo.
Pump motor combo, okay, so, my apologies. This pump motor combo, how was this pump motor combo? Can you describe what a pump motor combo is?
Yeah, so it's like a lot of people here probably have, city water, but it's like a well that you would have at your house if you live in a rural area. They are motor and pump. They're sized with different impeller trims that will push the water up to the aquifer a couple hundred feet. They're self-contained because they are sitting hundreds of feet below in the water. So you have to tear apart to repair the pigtail on these, which could allow water to get into the pump and motor that would render them inoperable.
So, what portion, what portion of this pump and pig, what portion of this was damaged? Was the entire thing damaged? Was this portion?
The power portion of it was damaged, and in order to repair the power side of it, you would have to splice the cable, which you would have to tear that pump apart, which is not recommended by the factory. It details the warranty. Then you're getting into a self-contained pump motor combo that's not meant to be tear apart. It's not something you maintain. It's a one-for-one maintenance item.
Okay, and does this item have some sort of copper in it?
Correct, yes,
okay.
The power cable would have copper in it.
Okay, and at some point you went and you surveyed these damages, right?
Correct.
And there was a portion, and can you describe again what was missing? Or can you just, I know you probably described it, but it went over my head. Can you
Yes,
just describe it?
so the power cable to these pump motor combos were missing. And the cut was too close to the casing, the head of the pump motor, that you would have to disassemble the pump motor combo to re-splice this.
And what is do you remember the value of these items that were damaged?
Yes, I believe there was a picture of the SIP, which we use for purchase orderings, and they had multiple prices on it. I think a couple of them were 14 grand, one was 19, one was somewhere in that ballpark, 12 or 13 as well.
If I showed you a picture of, or if I showed you a picture of or let me, I'll withdraw. Did you make an itemized list of the items that were damaged?
Yes.
And did that itemized list have the specific numbers of for the specific cost or the repair cost for these items that were damaged?
Yes.
If I showed you a picture of that, would that refresh your recollection about how much the total cost of this damaged product, how much that would cost?
Yes.
Is that an accurate depiction of the itemized list of the damaged product?
Correct, yes, from our purchase order system.
All right, so can you tell the court how much the total cost of those damaged items were? Or you could just say it individually, because
yes,
if you can't add it up together.
Math,
I'm an attorney, we're bad at math too, so you can just give her the individual line item.
We have one pump for 15, another for 15.
Now,
Another,
is that $15 or 15,000?
excuse me, I apologize, $15,602. There's two purchases for that. Another one's for $19,052, and another one for $14,995. Some change.
Okay. And did you have any additional involvement in the investigation?
No, I did not. I reached out to our security department to allow them to know so our budget can be met.
And did you itemize or did you provide police any information?
No, sir, we go to our security department. I never spoke to police.
Okay, so you just gave them an itemized list of how much it costs for accounting purposes?
Yes, sir.
No further questions.
I have no questions for this witness.
Thank you. Good afternoon, sir. So it looks like we have a total of 10 motors that were taken, right? Or damaged.
I do not believe that is true, I believe this skid was more like 5 or 6. I do see that there was each column in there.
Yeah, I see 1 each, 5 each, 3 each, and 1 each. So what was incorrect or correct about that?
Not all of those pumps that were purchased on that snapshot that was given was on the skid prepared for deployment in the field.
That's just showing the price range of these motors.
That's just showing the purchase order we made in a bulk purchase, and there was only.
How many motors were damaged or missing?
I believe the number was 6. It's been a few years.
Were any of the motors taken, or were they just damaged from where their lines were cut?
They were still there. The lines were just, the power cables were cut.
And to be clear, we're talking about braided line, right? The power line for these motors.
No.
When you refer to copper, it's not braided. What is?
I'd have to defer a little bit to my skilled trades.
Okay.
I'm not an expert on this.
Let's think of it this way if we can. My apologies, I cut you off. Think of a car battery, the cable lines, the leads. Is that kind of what we're thinking about?
Similar, yes.
So like a really thick gauge wire.
Correct.
Solid.
Correct.
You know, like 16 gauge, where it's probably, you know, like 2 inches wide or something maybe, right?
Correct.
How many feet on each of these motors would you have this lead wire?
I do not know that answer off the top of my head.
Any tubing at all? Any copper tubes located, you know, with these motors?
No.
Okay. So if we have any evidence of copper tubes being returned, that would not be from damage from your motors, right?
I do not believe so, but I'm not familiar with copper tube as well.
Sure.
I apologize.
But you work on these motors often and you know what it's taking.
I do not. I delegate. I'm just in management role
So you
there.
take somebody else's conclusion that they're inoperable and you're just reporting on that, right?
No, because I have spoke to the manufacturer. You would have to, I have enough knowledge to know that you'd have to tear that pump apart. You ruin the
So
warranty
yeah,
on that.
and all that knowledge, you're not aware of any tubes though.
I am not familiar with the verbiage of tubes. No.
Have you ever shown any pictures of items that were returned to any recycling businesses to determine if it was the same property that was taken more than one way?
No, furthest I went was with our security department.
So to your knowledge, it's never been recovered. Is that correct?
Correct.
Thank you. I have no further questions.
Can you redirect? Thank you, Mr. Tyler. You may be, Mr. Frey, you may be excused.
Thank you, Your Honor.
Any other?
So the people rest, John.
Okay, Garth, unless they're calling defense
I have
witnesses.
witnesses here.
I do have a witness, but before I call my witness, my client really needs to use the bathroom.
You have recess. Just gotta go.
Thank you.
we're back on the record. I'm gonna let you proceed to argument. I just want to note for the prosecution's purposes that no one has identified Ms. Dryden on this record.
I believe they did, Your Honor.
I believe I have a duty as an officer of the court to say that the individual from Padnos did say he knows remains.
Excuse me?
I believe I have an obligation as an officer of the court to correct report that the person from Padnos, AJ, said that he knows Ray and Sierra.
I know that he said he knows them.
I agree that I don't know that he
Yeah.
identified her as a person. He
Right,
said
the
he
only
knows her,
person that you
but
asked
from
me
what-
to identify on the record, yeah, he says he knows them, but he didn't point her out and identify.
I would agree with that, John.
I thought, it was my understanding that he did that. Okay, well. So Kristen.
I think there's a warrant for Mr. Berry out there.
For real.
Are you gonna make me scared like that, Judge?
They're waiting out the door, outside the door for you.
Literally,
They're waiting outside the door for you at this.
literally. Like Judge standing by the window.
Let me call.
Are you trying to get your witness back? Is that
Yes,
what you're
sir.
trying to do? I'm gonna have to, let's say, if you're not able to get him back here in short order, I'll just have to reset this for argument so that Mr. Berry can be released into courtroom one's custody. Okay, we'll continue argument to another date. Does May 14th work? Just Buckingham, are you helping with the homicide?
I'm sitting.
There you go. There you go. You can catch him. Ooh, very well, yeah.
Your Honor, is it possible to do the 15th, May 15th instead?
The 14th, I would only be able to be available in the afternoon.
We can do that. Well, she asked for it. So we could have did that. The afternoon is not available for you on the 14th?
Not really, no. As soon as we could do would be 3.
But why is it not available?
She doesn't get out of work until 2:30 on that day.
I work for defendants.
I'm also possibly in trial that day, likely in trial that day.
That's the 15th. Already. It's just find over argument. Impossible witness to formally identify. Right. Just like my notice that he just said, he specifically stated what this person was wearing. The guy from Pat, it's AJ from Pat. Specifically said he recognized Ray in the light jacket and then Sierra. He never pointed and identified who Sierra was.
If that's what you have written down,
May
my
15th.
understanding was a little different.
May 15th at 9:30. Yeah, because then I would have to ask, you would have to motion me to identify and I give her an option to object. You never did that.
He can't do the 15th.
You can't do the 15th. Oh, I thought you said you could do the 15th.
No, 14th afternoon. I can do it.
14th
15th
afternoon.
all day long.
Oh, the 14th is a what? Thursday?
So the earliest possible I could be here on the 14th would be like 2:30
Okay.
or on the 15th.
You said on the 15th? And
And
we
so
were
I
trying
could
to do the
potentially be
14th.
here at like 2:30
On the 14th?
on the 15th.
On the
14th, Ms. Robertson's not available.
You can do the 15th at 2:30.
So the 15th at 2:30.
Yes.
Okay.
Any additional matters today?
And the people will be just asking to open up back groups at that time and recall
Someone to identify.
someone
Got it.
to, yes,
That's fine.
AJ Manor.
That's fine.
We also have a witness.
You have a witness as well? Okay, sounds good.
Would you like me to take the photos and things back?
Yes,
for the-
please.
Did you say Grant Elliott?
Elliot, please.
Yep.
Yes, and then, oh, I think all Robinson's people are in custody. Got it. I don't know, she's showing the short stick over there.
Let me get your notes. real quick.
Word has a new file, is that what this one is? Oh. Hey. Is Ward here? Is he in custody?
He is, okay, so. he is-
I gotta get Elliott.
He got arrested on a new matter.
Right, I didn't know if
Stand behind the curtain. Yeah.
Yeah.
Okay, this is the state of Michigan versus Danton Kenneth Elliott, 26-01039, appearance please.
Good morning, Your Honor. Jennifer Lund on behalf of the people.
Good afternoon, Your Honor. Attorney Derek Etherton, Office of Public Defender, on behalf of Mr. Elliott, who's in the courtroom, standing to my right.
Okay, Mr. Elliott was scheduled for preliminary examination. I think it's stalking of a minor and then another stalking charge. My understanding is that there's some ongoing discovery and that the defendant needs a forensic evaluation. Is that accurate?
Yes, Your Honor, that's correct. The prosecutor and I have been in contact the last few days. There is further investigations, some forensic interviews that are being completed. I want to send him to forensics for a evaluation. I've been trying to collect some records and having some difficulty with that. That's why I don't have the petition today. However, I'm going to go ahead and get the petition done and get it to the court, hopefully by the end of today, with the information that I have.
Okay.
That's accurate, Your Honor. Mr. Etheridge and I have had numerous discussions. We are in agreement. I believe even just based on police reports that a competency referral is likely warranted. There are some ongoing investigation that is taking place. I think that will be completed by the time the competency referral is complete.
And then Mr. Elliott, how are you?
I'm doing good. How are you?
I'm doing well, thank you. You understand that you do have the right to have a preliminary examination within 21 days of the date that you're arraigned?
Yes.
Okay, and because your attorney is petitioning the court to have you evaluated, and because there's some ongoing discovery, are you willing to waive the timeline so that we can reset this? You don't have to.
No, I prefer not to. No, I'm pretty confident in my mental health.
I'll find good cause to go beyond the 21 days. I'll note, and it's been noted on the record that you have declined to waive your 21 days, and that you feel confident about your competency. What is the basis of the competency evaluation?
Your Honor, the allegations in the police report, the behavior, as well as the behavior leading the police to make a referral to the police social worker, and also to transporting to Sparrow as a PRT. He did get some information and some treatment from them and medications from them when he went to PRT, but he has only given me a brief summary or conclusion of what happened. He would not sign any releases for me to get reports. I've also had conversations with his mother by email, and my social workers talked to his mother, and she's expressed mental health concerns. He and I have talked about that, and he disagrees with her and says that's just her opinion. And I believe there was some allegations from something I just received today as part of a CPS referral, where the mother of his child has also raised competency and mental health issues as a concern.
Just to hold it. Just to make sure we get paperwork. To make sure we get paperwork, we can do for a PCC date. May 8th and 9:30. Okay, I'll set it for May 8th for a PCC. That's just to ensure that we get the competency paperwork
And then once we receive that and it's signed, it'll be set for internal review.
Thank you, Your Honor.
Thank you.
Your Honor, he did ask me to address bond with the court.
You can do so at this time.
Thank you, Your Honor. Your Honor, his bond is currently set at 50,000 cash surety. He advised me that once he was picked up and taken to the Sparrow Hospital for PRT, he lost his job and has no or very limited resources to post a bond that's sufficient. He's asking the court to consider a PR bond or low 10% bond with appropriate bond conditions. Your Honor, he is a very well-educated and expressive man. When you talk to him, he has a master's degree in business administration. He understands he can't go back to the house that he lives in, that he's purchased, and that he would have to get a different residence. And he advised me that he would attempt to stay at a hotel or with family members, but the family members would be in Detroit. He advised me he's willing to follow any bond conditions that would assure the court's confidence and safety to the public, including a GPS tether, following through with any mental health evaluations or treatment that may be ordered as part of his monitoring. Would like to try, if possible, to get out and try to get his job back, because he does have a daughter, 10-year-old daughter that he has to support and pay child support toward. He advised me. Based on that information, it would ask the court to consider reducing the bond with appropriate bond conditions to a PR bond or low 10% bond.
The prosecution will respond.
I'm sorry.
Did you want to respond?
Yes, thank you. Your Honor, people would object to any decrease in the bond. I do think that there is a significant ongoing threat to the safety of the public. In this case, there are multiple victims. Several of them are minor children. This defendant lives in the same trailer park as all of these victims, so he's in close proximity to all of these people. This harassment has been going on for several weeks. He's been told by the minor children's parents multiple times to leave them alone, and he continued with that behavior, which is what led to these charges. There have been multiple allegations that the defendant has some mental health, serious mental health issues, where he has some paranoia, especially paranoia as it may relate to these minor victims. Mr. Etheridge referenced a CPS report. There was a CPS report filed by the defendant's, the mother of his child, in early April, also expressing concerns about his mental health. That report included a statement that the defendant had purchased a shotgun a few weeks prior. Detective Lotkeys also was able to locate some information that on April 6th, the defendant registered a pistol in his name. The timing of the purchase of those firearms is concerning as it relates to these charges and to the mental health concerns as well. So I do think that for the safety of the public, I would ask that bond stay as is.
Regarding the guns, I did speak to him about the guns. He said that he did buy them legally, purchase them legally, and that he would have them placed with a family member or someone else for safekeeping while he was on bond.
I guess I would also be concerned about the defendant's ability to get himself to the forensic center for evaluation, especially if he doesn't think that's something that is necessary or warranted. If he's out on bond, that would be a concern as well.
Your Honor, I did discuss that with him, and he said he does have transportation. I told him if he didn't have transportation, all he has to do is let me know, and I'll have my social worker schedule the assessment or interview by video from the Office of Public Defender.
Okay, just reviewing the file, which I would say that the affidavit of probable cause is spans several pages long. But notably, there's a pretty extensive list. It says
it's a list of victims and their guardians. And then he's being charged in this with 2 counts of stalking a minor, and then one just straight stalking charge. Very concerning allegations, I would say, to say the least. And the concern also is that if he were to be released on bond, he'd be right back in the neighborhood or community where the protected parties are, which is also concerning. I think it's also concerning that while in the midst of these things, although they were purchased lawfully, the firearms are being purchased. And it seems like this was a situation where obviously multiple instances of unwanted or intimidating interactions having taken place between him and some minors and him and some other people from the community. The bond that was originally set, and again, I don't have his criminal history, but the bond that was originally set was set at 50,000 cash shorty with a GPS tether. It lists no contact with the protected persons, for the defendant to undergo a CAT or mental health evaluation. And now we're waiting for a now petition for him to undergo a competency, which he doesn't believe that he needs. I think the bond as that is appropriate. I will continue the bond at this time. Any additional matters for the record?
No, Your Honor, thank you.
No, Your Honor, thank you.
You're all set. Yes, who do you want brought next? Okay, we can bring up, is it Don Terrius Man?
Yes.
Are we running that one?
Yes.
I put it dead in my pocket, they kept picking it.
If it's a problem, they can get escorted out.
Oh, it's fine, but there was, this is why I'm picking on, there was an argument after I told you to do it. And I explained it now. I have issues in your. That's something. I'm growing honest. You have to keep it on me.
I'm assuming these people are here to support you?
Yeah, that's my son.
Okay, well, then you probably want to calm down if you want to stay here. Just, yes, ma'am. That's all you gotta do.
Yes, ma'am. Yes, ma'am. Anything else?
You can go.
Come on, now, sir. It's fine. I don't care. I'm a free man. It's free.
Be free.
It's not out to you when you come home. Talk about nothing,
What did you say when your son's in jail? That sounds crazy.
You threatening me? This is recorded. Are you threatening me, sir? Because at this point, we can take that to the prosecutor's discretion right now.
We're just trying to get through the week. We're so close, we're just so close. We're just trying to get through Friday. We know where the prosecutor is. No, I don't know where they got it.
No one wants to.
This is Mr. Mance, correct? Okay, on the record, in the matter of the people of the state of Michigan versus Dontarius Mans 26-01032. Appearance, please.
Thank you, Your Honor. May I please report Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Mans.
Okay, this is scheduled for a preliminary examination. My understanding is that we're ready to call witnesses on this.
Yes, Your Honor.
That's correct.
Need preliminary.
Yes, Your Honor. At this time, we, the people are going to move to dismiss count 2, assault with a dangerous weapon.
Okay, so that leaves count 1, weapons, carrying concealed, and count 3, felony firearms.
Yes.
You can call your witness.
The people call Officer Gleasner.
I think he went to the library. Or maybe the office is down there. Because there was no officers down here. It was just donuts in that room. He said I guess the prosecutor brought him in because he knew it was gonna be a long day. Got y'all some too, that was nice. Yeah. That was nice.
Because that's the police report. It's on the test. Police report isn't coming in.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
You can have a seat. State your first and last name and spell both.
Lucas Gleasner, LuciasBliesner.
Thank you. Proceed, counsel.
Thank you, Your Honor. Officer Gleasner, this is your first time testifying, right?
Yes.
Nothing to worry about. Just, just talk about what happened on April 14th, right? Or are you currently employed?
Yes, I'm currently employed through the city of Lansing.
What's your position with the city of Lansing?
Lansing police officer.
How long have you been a police officer with Lansing?
Been a police officer about 3 months now.
3 months, okay, still new. And what's your role with the Lansing Police Department?
Patrol officer, currently through FBO right now.
And just describe some of your duties as a patrol officer.
Primary duties is taking calls for service, traffic enforcement, etc.
And were you employed in that capacity on April 14th of this year?
Yes, sir.
And I'm going to direct your attention to April 14th, approximately 2,300 hours. Did your tour of duty on that day take you to 6215 Groveberg Road?
Yes, sir.
Do you see anyone present in court who you saw at that time in that location?
Yes, sir.
Can you identify that person by an article of clothing and where they're seated in the courtroom?
This gentleman right here.
Where is he seated? Next to the defense. The gentleman by an article of clothing. What is he wearing?
Gray scrub jacket. Is that man's?
Gray or blue? Yeah.
Yeah, okay.
Is it gray or blue?
Looks gray.
Okay. Your Honor, let the record reflect that witnesses identified the defendant.
Any objection?
No objection for purposes of preliminary exam.
Okay, so tell the court what brought you to that location. What was the nature of that call?
The original reason we were called out there was the homeowner, I believe, called in reference to a bunch of people showing up in a vehicle. We were informed that a weapon was involved. And at that point, we got on scene and just broke it down one by one. Me and Officer Moshi, we discovered their vehicle like parked out front. So we started asking people out, detaining them. Eventually, other officers located a firearm, and at that point, we were investigating a CCW charge.
And this happened, did this happen in the city of Lansing?
Yes.
Ingham County?
Yes.
State of Michigan?
Yes.
Okay. So you arrive on scene for a, tell me again, what was the original call for?
The original call did, it was between like an assault and a weapons complaint.
And then when you arrive on scene, you said, at some point it turned into, CCW, investigation.
Correct.
Right? All right, so when it turned into a CCW investigation, what was your involvement in that investigation?
So due to the amount of passengers that were located in the vehicle, Officer Moshi was asking them out, and then they were originally detained behind the car. We moved them over to the curb. Once the weapon was located, I was kind of on like the far left of their stack along the street, which is where Mans was located. So I detained Mans in handcuffs and put him in the back of the patrol car.
Why did you detain Mans?
Due to the CCW charge, we were investigating a crime at that point.
Okay. So, again, let me get this straight. The original call was for an assault.
Yes.
And then you arrive on scene and there's a car full of people.
Is that a yes?
Yes, yes.
And then, the original complaint, someone said there was a gun.
Yes.
With that assault. And in order to do your investigation, you had to ask the individuals out of the car.
Yes.
So, was there anything that you identified in the car, or was there something there that that you asked the people to get out of the car? Why did you ask them out of the car?
Due to the amount of people in the car and not exactly knowing what we had at the time, we asked them all to get out just so we could essentially, I don't know, have it be safer and not have a whole bunch of people we don't know in a vehicle when we're investigating a crime.
And did you locate anything in the vehicle?
Yes, other officers located brass knuckles and.
No, did you locate anything in the vehicle?
I did not know. I did not search the car.
You did not search the car. So why did you place the defendant under arrest?
Due to the amount of people on the scene, we were investigating the CCW due to like how many of them there were. We wanted to separate them and just to avoid like potential flight from the scene, we chose to handcuff everyone just for the length of like that detention to investigate the CCW.
Do you know where the gun was located? Or was there a gun recovered in this through your investigation?
Yes.
Where was that located?
I believe it was located in the driver's side.
I'm gonna object based on, I don't know if he has actual knowledge of
You didn't
this.
locate the gun, did you?
I did not locate the gun.
Call for hearsay.
Okay. Did you have, did there come a time where you ran the defendant's lead, his criminal history?
Yes.
What did you find out based off his criminal history?
He was on probation for like firearm charge.
Are you aware of any restrictions that a person's on probation for? You may not. Or you've just been here for 3 months, so you may not know the restrictions.
I do not.
You don't know. Okay. But you found out that he was on probation.
Yes.
Did you have any other interaction with the defendant through your investigation?
No.
Did you do a subsequent follow-up investigation with him? No.
What do you mean?
Did you, so was that the last time you spoke to the defendant is when you arrested him on the scene?
Yes.
No further questions.
I have questions because I'm like completely lost as to what's going on here. Give me your last name again, officer.
Bleasner.
Policeman, Officer Policeman. You arrived to the area 6215 Grovenberg, and are people outside or inside of a car? Where are they?
They're inside the vehicle.
Okay, so how many people were inside the vehicle?
I don't know the exact number, Your Honor.
Okay, and then you took custody of the person you identified as the defendant?
Yes.
Okay, and where was he located in the vehicle? Was he in the vehicle?
Yes.
Okay, where was he located?
The far back, like the far back seat.
What does that mean, far back seat? I don't know.
Like there's the driver and passenger, then there's like the second row. You would have been in the third row of the.
Okay,
vehicle.
what kind of vehicle is this?
I refer to my report.
You don't, yeah, because obviously this must be a large vehicle. There's a third row seating is what you're saying?
Yes.
And he's in the third row?
Yes, there's a Traverse Escalade.
Traverse Escalade. Okay, and he's in the third row and driver or passenger side?
Driver's side.
Okay, and so everyone was ordered out of the vehicle?
Yes, Your Honor.
Okay, thank you. You can cross-examine.
So Officer Bleisner, is it Bleisner?
Bleisner.
Bleisner, okay, sorry. You were called to the scene of an assault or possible weapons case, correct?
Yes.
And you were not the initial officer on scene, correct?
Yes.
All right, so when you arrived on the scene, there were already officers present, correct?
Yes.
And was a traffic stop being conducted at that point in time?
No.
No, okay, it was about to be conducted then.
Yes.
Okay. Were you the officer that conducted the traffic stop?
No.
Okay, so you basically were only involved in this case by securing some of the passengers in the vehicle, correct?
Correct.
Nothing further.
Redirect.
No redirect.
Thank you, Officer Policeman.
We'll call Officer Gutenberg.
Yeah. What they did. No, I know. He wrote the wrong hand. So we raise your weapon. He did. I didn't even notice that. That's crazy. Yeah. I just he must be he attended too. Oh, he's like probably 19 now. It's like 19 now. That's interesting. That is big road. I said, I gotta get from school. You say, can I get home from school? I got a 2. At 2? I got a 2. No, at 3:30. Oh. Oh, yeah. What's happening? Is he telling you what the stuff about? Can you go see what he's doing out there?
Yeah.
The officer in the hallway.
saying right there, she's gonna swear you in and
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can have a seat. You can state your first and last name and spell both.
Ethan Grunberg,
spell.
Ethan Grunberg, Grunberg.
You can proceed, counsel.
Thank you, Your Honor. Officer Grunberg, are you currently employed? Looks like you are.
Yes, sir.
Well, and where are you currently employed?
I'm employed with the City of Lansing Police Department.
And how long have you been with the Lansing Police Department?
5 months.
What's your current assignment?
I'm assigned to the patrol division.
Can you describe some activities that you do as a patrol officer?
Absolutely. I respond to calls for service in the city of Lansing, including violent crimes, assaults, traffic, anything of the following.
Okay. And I'm going to direct your attention to April 14th, 2026. Of this April 14th of this year. Were you on duty on that day?
I was.
Did your tour of duty take you to 6215 Grovenberg Road?
It did.
Could you describe to the court what brought you to that location?
So I was assigned night shift. I was working in the south side of the city of Lansing. I received a call for service reference a weapons complaint. The call came in as a group of unknown individuals in a black Chevy Traverse jumped the caller and their friends. And as well, there was a gun seen in that incident.
Okay. And when you arrived on scene, so you were dispatched related to that call.
Correct.
And when you arrived on scene, describe describe what you saw when you arrived.
On scene, I saw various officers having people of the black Traverse step out of the vehicle. There was about 7 people that were getting stepped out, and they were getting just moved outside of the car. Following that, they were basically just getting people that were inside of the vehicle separated from the car.
And at some point, what happened after that?
Yeah, so after that, I approached the passenger side of the vehicle to verify that there's nobody left inside. I appeared to look in the front passenger driver's seat when I noticed a pair of brass knuckles in front of the center console, as well as I located open alcohol. From there, myself, Officer Moshi, and Officer Vasquez searched the car to look for any further weapons or open alcohol.
And what happened as a result of your search?
As a result of my search, I recovered the brass knuckles as well as the open alcohol, and I witnessed Officer Vasquez recover a bronze and black Glock 19X with an extended magazine from the back driver's side seat of the vehicle.
Back driver's side. So on the driver's side in the back.
Correct.
Okay. So after you uncovered the weapons and the alcohol, what else? What did you do after that?
After doing that, I grabbed a K-pack for our evidence, and I placed the brass knuckles inside of that K-pack and secured it in my patrol car. Following that, I was assigned to stand watch over 3 females who were all in custody after everybody in the car was placed in handcuffs.
And what happened after that?
After that, I was informed that one of the females that I was watching over who was in custody was going to be found in possession of the CCW for the brass knuckles, and we transferred her to LP lockup.
And at some point, was the defendant arrested?
Correct.
Why was he arrested?
He was arrested in connection to the firearm that we recovered.
What was your understanding why he was arrested?
I was under the impression that
Objection, hearsay.
What I said, well, my question was, what is your understanding?
You're addressing an objection.
Yeah, so my question was, what is his understanding, his personal knowledge of why the defendant was arrested?
His personal knowledge will call for hearsay, correct? How would he know?
Huh?
How would he know?
Okay.
Because he didn't place him under arrest.
Okay, I will withdraw. Do you know why the defendant was arrested?
I do.
Again, we call for hearsay.
Well, ask him how does he know first.
I
I don't know how he knows. I don't know.
That was gonna be my next. How do you, so you know why the defendant was arrested? Right?
Correct.
How do you know that?
It was determined that the firearm that was recovered from the vehicle belonged to Mr. Mann.
You mean it was determined? Who determined that?
Officers on scene.
Okay, you didn't make that determination?
I did not.
So you heard someone say this? Is that what you're suggesting?
My partner told me that that's what
Objection
happening.
sustained.
Okay, where was the, you said, where was the gun located?
So in that Chevy Traverse, it's kind of like 3 seats. So it has the front driver's seat and the passenger seat. Behind that is a row, and then following that is a row. So in that second row, it was on the driver's side, tucked underneath the seat.
You said in the second row?
Correct. So that would have been the first seat directly behind the driver.
It was tucked
underneath that seat.
Oh. Did you see it there, sir?
I did not.
Oh, okay. Someone told you that's where it was?
I watched Officer Vasquez reach behind that seat and pull it out and recover it.
So it was up under the driver's seat?
Not the driver's seat, but that seat behind.
It was under the seat behind the driver's seat?
Yeah, so there's in that vehicle, there was the driver's seat.
Okay.
The second, I'd consider that the first row, and then it was tucked in between there and that back row.
Because there's 3 rows?
Correct.
Okay, so it would have been in front of where the 3rd row in the
Correct.
seat. Got it. Okay, thank you.
And where was the defendant located in the car?
I do not know.
Okay, after you, after the defendant was arrested, did you have were you involved in further investigation?
I was.
And as a result of that, tell us what you uncovered as a result of that investigation.
Absolutely. So as a result of my follow-up investigation, I wanted to speak with Mr. Manns about the firearm that we found in the vehicle. In addition, I recovered 2 buckle swabs of Mr. Manns' DNA. Mr. Manns is adamant that the firearm was not his. And I learned through further questioning that he witnessed his brother's friend, Deshaun, who was concealing the firearm in his waistband. He could see the imprint of it. Before, when the police got there, he pulled the firearm out from underneath his sweatshirt, handed it to an unknown female. That was what I learned to the left of Mr. Manns, who was sitting in the center on the floor of that second row. And she tucked it underneath the seat, according to Mr. Manns.
And he had knowledge. So based off of your conversation with him, you uncovered that he had knowledge.
Objection calls for a legal conclusion.
The question was, he had knowledge of what?
Based off of his conversation with the defendant, was it your understanding that he had knowledge that the gun was there?
Yes.
But no, the judge.
Yeah, if there's an objection, I have to tell you,
Sorry,
to give you the
my fault.
response.
I'm sorry.
You're asking if it was his understanding that he has knowledge, and you said it would cause for a legal conclusion?
Correct. So part of the elements of the cases is that he has to prove that the defendant had knowledge that there was a weapon in the vehicle. He can't just ask.
I agree. Objection sustained.
So, in your investigation, did you have any other follow-up investigation?
I did not.
Okay. Where did the investigation take place?
My investigation took place in interview 1 of the LPD lockup, our detention center.
And at some point, did you uncover the defendant's criminal history?
I did.
What's his criminal history?
So to my understanding, Mr. Manns is on probation.
I'm gonna object as to relevancy.
Because his probation prohibits him from being in or around firearms. So I think that's relevant to the other testimony that you.
Well, you asked in general what his criminal history was, but I'm going to sustain the objection. I think the court is clear that he was on probation at this point. And not to be, so we don't need to get into his entire criminal history.
Okay. And why did you take a swab of his, a buccal swab?
I took a buccal swab in order to match any potential DNA from Mr. Mance to the firearm.
Do you know if that, and you, what happened after that? Did you submit that?
After that, yes, I submitted that to evidence.
Who made the decision to do the buccal swab?
I did.
Why did you do that?
Whenever I recover a firearm on the road, based on my experience from my work in the past, I always try to get DNA of people who are in possession of firearms to see if they'll consent to a buccal swab their DNA.
And you did, why did you do that?
I did that in order to, if there was any DNA that was on the firearm that matched Mr. Mance to the firearm, that would kind of essentially prove that Mr. Mance has been in possession of that firearm at some point.
Okay, no further questions.
What is your past experience, sir?
I was a contract employee with the Bureau of Alcohol, Tobacco, Firearms, and Explosives for 6 months.
Oh, okay, so that's when you say, based on your experience in the past, that's what you're talking about?
Yes, ma'am.
Okay, and then the DNA was turned over, was there a match?
I am not aware of the match yet. When I submitted the DNA, it goes to the Michigan State Police.
Haven't
lab.
gotten results yet?
I have not gotten results yet. I
Yeah,
think
they
that would be
don't move
notified.
that quickly, typically. Okay, cross-exam.
Officer Gruenberg, you arrived to the scene once the traffic stop was already underway, is that correct?
Correct.
Okay, so you didn't see originally where people were seated in the vehicle?
I did not.
Okay, and everybody was already outside of the vehicle at the time that you arrived on the scene, correct?
When I arrived on scene, more people were getting exited out the vehicle and patted down for safety.
Okay, so they were in the process of getting out of the car.
Correct.
Okay. Now, you stated that you recovered DNA for Mr. Mans. Did you submit the firearms that was found for any additional testing?
I did not. Officer Vasquez handled the evidence collection and recovery of the firearm.
Okay, so the only evidence that you collected and submitted for testing was the buccal swabs, correct?
Correct.
Besides having that one statement from Mr. Mans while in lockup, did you have any other involvement in the case?
No.
Nothing further.
Redirect.
No redirect.
Thank you, officer. You may be excused.
Thank you, Your Honor.
Thank you for your witness.
People rest.
Any defense witnesses?
Not at this time.
You can proceed to argument.
Thank you, Your Honor. I believe the people have sufficiently met our burden here for at least the probable cause standard. And you heard testimony today that Officer Gruenberg, to follow up on, let's start off at the beginning. You heard testimony that officers were called to the scene for a assault with a weapon complaint. As a result of Lansing police were dispatched to the location in which they encountered the defendant. Defendant was in the vehicle with approximately 7 other people. They were asked to exit the vehicle. due to the nature of that complaint, police found Officer Grutenberg's, I have stated that he found brass knuckles in the car and some open alcohol, so they did a further investigation. They located the firearm in the vehicle. Officer Grutenberg did an additional follow-up with the defendant, and the defendant personally stated to him that he had knowledge that the gun was in the car, and that he knew exactly where the gun was located. You also heard testimony that the defendant is currently on probation. As a term of that probation, he's not supposed to be anywhere near firearms. So at this time, we believe that we've met our burden to establish that for a constructive possession theory, that the defendant did know that there was a weapon in the car. He was riding in the car with that weapon, and I believe based on his own statements to police that we have met our standard, that he knew that there was a firearm in the car, and he was located in the vehicle where that firearm was located.
Yes, Your Honor, I don't believe that there's probable cause to proceed on the carrying concealed weapon in this case. If you look at to what was testified to in this case, it looks like all we have is that there were about 8 people that were in a car. A firearm was found in the back. Mr. Mans was one of the people that was in the car that was alleged to be in the very back of the vehicle. But we don't know where anybody else was sitting. We don't know what they were doing. We did hear from Officer Gruenberg, who stated that he himself did not find any sort of firearm, but he saw Officer Vasquez find pull a pistol, I guess, out of the front or behind the front passenger seat in one of the rear back seats of the vehicle. But beyond that, didn't know anything else about the firearm. Also stated that he was able to speak to Mr. Mans, and Mr. Mans stated that Mr. Mann stated that he saw a person, a Deshaun, took a firearm into his shirt, and that another female took the firearm out of his shirt before the vehicle was stopped. The people want to suggest that that says that Mr. Mans had knowledge that there was a firearm in the vehicle at the time. I mean, I don't think that that would be enough to say that there would be knowledge that he knew that there was a firearm in the vehicle the entire time that he was in the vehicle. Seems that he saw that it was on someone's person right as the vehicle was stopped, and that it was placed by someone, that it was in the vehicle. I don't think that you can say that that is enough to imply that he knew at the time that he was getting into the vehicle that the firearm was in the vehicle, and he knew that he was there the entire time. As far as it goes to, we did hear that Mr. Mans was on probation. I think the court can probably infer that you're not supposed to be around firearms while on probation, but we didn't hear anything about what he's on probation for, the conditions of his probation. That was not offered into evidence in this case.
But they said he was on probation for weapons.
For a firearms offense, but there wasn't any like, I guess like we don't have the terms of his probation or his probationary contract, the rules of his probation.
I can set dollars to donuts, but if he's on probation for a firearms charge, then he can't be in possession of firearms. The other thing is, he 20 years old?
Yeah. Yes. 20.
So I don't know that he has a lawful CPL.
But based on that, Your Honor, I don't think that there's enough evidence here to show that that he was in constructive possession of this firearm. Just based on the fact that we don't have any evidence of what was going on in the vehicle, who was being pulled out of the vehicle, where other people were sitting. There's not really much evidence here, just besides his statement alone, and we can't just use his statement in order to prove an element of the offense. There has to be additional evidence. So I'd ask that probable cause not be found.
Just a short, brief follow-up. So the number two, the second element in the is that we have to prove the defendant concealed on or about his person, or whether concealed or otherwise in a vehicle operated or occupied by the defendant. You definitely heard testimony that he was in that vehicle. You definitely heard testimony that he was aware that there was a gun in the vehicle. And this wasn't like it was an actual traffic stop. They had already been stopped at this location. And when police got there in respect to the felony of the felonious assault case, they were all just seated in the vehicle. So this wasn't like, you know, a normal traffic stop. So based off the testimony, I believe we met that burden for that.
Today was the day scheduled for preliminary examination. The burden is on the prosecutor. They need to establish sufficient evidence based on a probable cause standard that the felonies that you're being charged with, now it's count 1, weapons carrying concealed, and count 2, a felony firearm, were committed. And then a probable cause that you were the person to have committed the crime. This is not trial. They don't have to prove each element beyond a reasonable doubt, just more than mere suspicion. The court will also assess and weigh any credibility issues and the people's likelihood of success at the time of trial. We had testimony today from 2 officers, first being Officer Belisner, I believe is how we pronounce his name. And he testified that on the date of April 14th, 2026, he reported to the area along with other officers to 6215 Grovenberg Road that he was called due to a bunch of people showing up in a vehicle and informed that weapons were involved. And he testified that he took the defendant into custody due to the investigation of a CCW charge, and due to the amount of people on the scene that people were detained with handcuffs, I guess, because of safety of securing the scene. He testified that the defendant was inside of a Traverse Escalade, and that the defendant was in the 3rd row of the vehicle. We then heard testimony from Officer Ethan Gruenberg. He testified on the same date and time that he arrived to the scene of the alleged incident. And he looked in the front driver's side, and in plain sight, he identified some brass knuckles and open alcohol. Based on that, officers did a search of the vehicle. He being Officer Gruenberg, testified that he witnessed another officer recover a firearm from the back seat that would have been positioned in front of the 3rd row seating. So likely the way that it was positioned, it would have been placed there by someone who was sitting in the 3rd row. It was, he said, tucked under the 2nd row of driver's side. He testified, Officer Gruenberg doesn't know where exactly the defendant was seated in the vehicle. He said that he later interviewed the defendant. The defendant advised that it was not his firearm, that he witnessed another female tuck it under the seat after it had been passed to her from another occupant of the vehicle. It sounds like there has been some buccal swabs tests done to see if the defendant's DNA is on this firearm. I think that right there could clear this all the way up. His DNA is not on there. He didn't have anything to do with it. And The other issue is we cannot move forward with constructive possession just because he saw it as it was being placed under. It would have to be more than, or something more like he saw it before that. It can't be as we're exiting, I see someone put it under there, and now I'm charged with constructive possession. However, in this case, we have more than that because we have the whole reason for the call was because of a weapon. Somebody called because they knew there was a weapon in the vehicle. So if someone outside the vehicle who could call the police said there's a weapon in the vehicle, they knew it, then the court has more than probable cause to believe that the defendant knew that there was a firearm in the vehicle. I don't know if he took part in keeping it there. Based off where it was located, there's probable cause to believe that he took part in believing it because it could have been that he put it under there, but that could be easily flushed out if his DNA is not on the firearm. If the DNA is not on the firearm, then what he stated makes sense that someone else put it under there. As maybe as they were exiting, I don't know. The other issue is I think it's still unclear. I don't, there was at least another person, I believe, and that I don't know if that came in, that someone else might have been in the backseat. The only reason I can assume that is because there's 7 to 8 people in this vehicle, and I don't see how they all could be in the front. But the only persons that we know are in the back. I don't know who the alleged young lady is or where she was seated in the vehicle, nor the other person that allegedly passed I think it's the Deshaun who passed the firearm to her. If that was the first time the defendant saw the firearm, then no, there was no constructive possession. If, however, the defendant saw, because obviously this allegation that led to the call is in fact true, then he knew prior to that there was a firearm in the vehicle, or if his DNA is on there, he likely was the one who was operating or handling the firearm. So I think that at this point, there's at minimum a question of fact that needs to be fleshed out at the circuit court. So for those reasons, the court's going to bind this over to the circuit court for further prosecution on count 1, weapons carrying concealed and felony firearm, based on the testimony that the defendant is currently on probation for a felony weapons charged. Bind over date is going to be May 13th. That's the date the circuit court's receiving the file from the district court, not a date that Mr. Mans has to appear in the circuit court. His next court date will be a pre-trial in circuit court, and his attorney will be made aware of that next date. Let's see. What's going on with the felonies? He's still on probation?
Yes, Your Honor, our office is currently looking to see if we will be able to revoke that probation. I believe this is going to be a subject of a probation violation in that other case.
Well, I would imagine it would be a probation violation. I just don't know if it's violation or if it was revoked. I know the seriousness of the allegation is now diminished because of the count 2 being dismissed. But bond is set right now at $250,000 cash surety. Are we addressing bond?
Yes, Your Honor, I would like to address bond. I would ask that this bond amount is particularly rather high. I understand that Mr. Mans is on probation up in circuit court. However, it does seem that this amount is rather high. He has been in Lansing his entire life. He does have family in the area, and he does have family here today that are supporting him. We would ask for a more reasonable bond, one that would be something that Mr. Mans would be able to post. But 250,000 cash surety, it seems rather high at this time.
I'm reviewing this. He's got more than one case. He's got another gun case. It says here in the bond recommendation that the defendant is currently on probation in circuit court for a carrying concealed weapon. That's in file number 25-02398, and he was sentenced on August 6, 2025. Additionally, defendant is on bond in the circuit court for a separate concealed weapon file that occurred on August 8th. Is that accurate?
He is on bond for 256581 FH. correct?
Okay, so on probation for CCW, then 2 days after you are sentenced, allegedly you pick up a new CCW. That's still pending. That one.
So he's on probation for 252398, and then he has another open case, 256581. And there's this, so I guess that's.
So this is the third charged weapons offense that the defendant has had in the past 12 months. Just based on the nature of the assault being dismissed, I'll reduce the bond, but I do think there's a threat to safety. We've got a young man now with 3 pending weapons charges, one of which she's got a conviction for. The other one is pending, and that was for a charge that allegedly took place 2 days after sentencing. Even if it is determined based on evidence from the swabs that he never handled this, he has no business being around it, and based off the 911 call, someone outside knew there was a firearm there, so he should have known. And this is a serious threat to our community. A serious threat. I don't know why young boys and girls are running around here with firearms like they're toys. People's lives are being taken left and right. We had the Lansing Public Schools on lockdown this week because people, your peers, are terrorizing a community. And it's problematic, and something needs to be done. And if you can't fix your mind around this is problematic behavior that I shouldn't engage in, nor should I condone or be around, then the court has no choice but to leave you in a cage, which is what we call jail, because you can't control your own behavior. The bond is going to be amended to 100,000 cash surety with GPS tether. All other bond conditions will continue. That includes a complete home arrest and not to leave your residence unless it's for medical, legal appointments, or court proceedings. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Thank you.
No, but we're gonna have to ask for a continuance.
For James, I mean for Ward?
For Ward,
It's
yeah,
gotta be arraigned though, so he can be brought up.
right, yeah.
Okay, did they send me the file?
The file for.
I said I will, I agree. On the record in the matter of the state of Michigan versus James Ward II. This is 26-01023. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith here on behalf of the people.
Karen Robinson, Assistant Public Defender for Mr. Ward.
Okay, Mr. Ward was scheduled today for a preliminary examination. This was for a domestic violence third offense. However, the court did receive a new file today and a notice of bond violation. I'm assuming it's for the same file. So I need to arraign him now on the new file, which is for another domestic violence third offense notice and a assault with a dangerous weapon. In file number 26-01086. I have here an allegation that on or about May. I have to be wrong here. Violation must be something different.
Yes, Your Honor, I think the violation was for an alleged no contact order.
Okay, got it. Because this is from March 11th. Oh, they're not the same, so we'll arraign you on both. Okay, so I have here the felony complaint that alleges that on or about March 11th, 2026, at the area of 913 West Holmes Road, Lansing, Michigan, that you allegedly assaulted and battered a Teresa Lynn Averill, an individual whom you have a dating relationship. That this was contrary to MTL 750.81. It's a 93-day misdemeanor normally. If the assault was committed in a place of confinement, the court may order the sentence for this offense to run consecutively to any sentence the defendant was serving or to the sentence for the offense for which the defendant is being detained. There is, however, a subsequent or third offense notice. It says take notice that the defendant was previously convicted of assaulting and battering the defendant's spouse, defendant's former spouse, individuals whom the defendant had a child in common, defendant with whom the defendant had a dating relationship or resident or former resident in the defendant's household, or of knowingly assaulting a pregnant individual in violation of MTL 750.812. On or about April 18, 2022, in the 30th Circuit Court, and MCL 750813, assault or assault and battering a pregnant individual on or about October 16th, 2018 in the 54A District Court. Therefore, upon conviction, the defendant will be subject to an enhanced sentence under MCL 750.815. That makes count one a felony, maximum penalty 5 years in prison and or $5,000 in fine. If the assault was committed in a place of confinement, again, the court may order the sentence for this offense to run consecutively to any sentence the defendant was serving or to the sentence for the offense for which the defendant was being detained. There's a count two of assault with a dangerous weapon, also called felonious assault. The allegations are that on or about March 11, 2026, at 913 West Holmes Road, Lansing, Michigan, that you did make an assault upon Teresa Lynn Averill with a dangerous weapon, that being with a truck, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, and that this is contrary to MCL 750.82. Count two is a felony. Maximum penalty is 4 years in prison and or $2,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You have the right to be represented by an attorney in this matter. I should also note that there has been a notice of intent to seek enhanced sentence as a second habitual offender under MCL 769.12. I'm sorry, 10 has been filed in this felony file as well. Again, you have the right to an attorney. Your attorney, Ms. Robinson, is here today for the purpose of your arraignment. And you have the right to make a request to have a public defender represent you at each stage of the criminal prosecution. You are represented by public defense and other matters. I'll note here that you are seeking court-appointed counsel on this one as well. The court will also enter a plea of not guilty on your behalf. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue all the way to a jury trial. You are being charged with felony in this matter, or felonies. You have the right to have a preliminary examination within 21 days of today's date, unless you waive the 21 days or the court finds good cause to go beyond the 21 days. You are currently scheduled for probable cause conference before me on May 14th at 8:30. You have a preliminary examination before me on May 21st at 8:30 in person at the court. You have the right to proceed to trial, the right to jury trial, the presumption of innocence until proven guilty, the right to require the prosecutor to prove your guilt by proving each element of each of the charges beyond a reasonable doubt. You have the right to see, hear, or question any witness called to testify against you, the right to call your own witnesses or present evidence that you believe shows offense to these charges, and the right to subpoena witnesses that will testify on your behalf. We have an address for you at 5012 Richmond. Is that still accurate?
Yes, ma'am.
And the last time I saw you, which was a couple of weeks ago, you were supposed to be moving to 3200 South Washington. Is that still happening?
I haven't got the moving date yet. They had something with the paperwork I was supposed to go in and fix actually today, but.
And you are on probation before me.
Yeah.
And you have another matter before me. And what's your phone number?
517-203-9051.
So we also have a bond violation here. The allegations are that on or about May 1st, that you, that's today. That was today. It says on or about May 1st at 0200 hours, that you made contact directly or indirectly with the protected party, Brittany Renee Anderson, in violation of your bond conditions. So you have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing. If you're found to be in violation of your bond conditions, your bond can be revoked and you could be placed in jail pending the ultimate resolution on these matters. You also could be facing a sentence or contempt of court of up to 93 days in jail. Do you understand that? How is he pleading on the bond violation?
Not guilty, Your Honor.
He will plead not guilty on bond violation. That will be set for a hearing. And you were scheduled today for a preliminary examination with my court on this, so we're going to find good cause to reset this.
Do we just want to put it with this other case? Okay.
We're gonna do it all together. As it, let's see. It's a different victim though, isn't it?
No, they're different.
Yeah, it's a different victim, right?
Yes.
That's what I thought, okay. On the new file, there will be a no contact order that's going to be in place for the protection of the alleged victim, Teresa Lynn Averill. You're not to travel outside the state. You're not to use drugs or alcohol. You're not to possess a firearm, ammunition, or weapon of any kind. You wouldn't need to report to pretrial services within 48 hours. I am going to order GPS tether. Personal reconnaissance bond would not be appropriate under the circumstances. You're going to be remanded for a hearing and exam on file number 26-01023. And on the new file, your bond is set at 10,000 cash surety with GPS tether. Any additional matters for the record?
No, Your Honor.